Good evening. I'm going to call the December 20th meeting of the Highland Park Planning Board to order. This meeting has been noticed in accordance with the Public Meetings Act. In accordance with the Open Public Meetings Act, notice of this meeting has been provided by filing a copy thereof with the Home News Tribune, the Star Ledger, the Highland Park Mirror, and the Highland Park Monitor on January 20th, 2012, and by posting a copy thereof on the Borough of Highland Park website and on the bulletin board on the main floor of Borough Hall. The fire exits are located to the left and right of council chambers. So, roll call, Diane, please.
Okay. Ms. Hammond?
Here.
Mr. Siegel? Mr. Kluger?
Here.
Ms. Greenberg? Mr. Linares?
Here.
Mr. Williams?
Here.
Ms. Auvere?
Here.
Mr. Luthman?
Here.
Ms. Wilkerson? And I have a question about Mr. Millay. Do we call his name? He's recused himself from this.
Sure.
Okay, Mr. Millay is not here.
Okay, so the first thing I want to do is approve the minutes from our May, June, July, and August meetings. They've been distributed. I know everyone's had time to review them. Does anyone from the board have any comments regarding? We'll do the May minutes first. Any comments or corrections? No? Seeing none, do I have a motion to approve the May 17th minutes?
So moved.
Second
Paul,
that.
do we have a second? Terry? We'll just do a voice call. All in favor?
Aye.
Aye.
Any opposed? And any abstentions? Okay. Moving on to June, same thing. Do we have any comments or corrections? These are the minutes for June 21st. Seeing none, do we have a motion to approve the minutes?
So moved.
Paul, and a second?
Second.
All in favor?
Aye.
Aye. Any opposed? And any abstentions? Okay, moving on to our July 19th minutes. Any comments or corrections? Okay, seeing none, do we have a motion to accept?
Motion to accept.
Alan, and a
Second.
second? Terry? Thank you. Voice, sorry, all in favor?
Aye.
Any opposed? And any abstentions? Okay, our August 16th minutes, same thing. Do we have any comments or corrections? Nope. Seeing none. Do I have a motion?
To accept.
Alan, and a second?
Second.
Terry? All in favor? Aye.
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 Any opposed? And any abstentions? Okay, thank you. That's great.
Thank you.
Okay, so we can now move on to the application that we've had before us regarding the 7-Eleven and Continental Global Ventures. We're going to continue with Ms. Monahan, who is representing an objectors group, HP Future.
Point of order, Madam Chair. I'm sorry, I have a point of order. My name is Matthew Hirsch. I'm chair of the Borough's Public Information Committee.
Okay.
I spoke with, I think it might be good if you or Mr. Thomas indicated what this presentation is about, considering it's not an agenda item, nor are the materials available for the public. Considering that we have cable TV here tonight, it might be good for folks watching at home to understand why members of the public have proprietary involvement in offering.
Sure.
I'll be happy to do that. This is an agenda item. This is a part of the hearing that's been going on since May the 17th. This is part of the Continental Global application. At this moment, the applicant, Continental, has rested its case. Therefore, the meeting is open to the public. Ms. Monahan is representing a group in the public. She has the right to respond to the presentation that's been made by the applicant. She is in the process of doing that. She started that at the meeting in November. She is continuing on. Then there will be an opportunity for other members of the public who are not part of that group to have their opportunity to be heard. Excuse me. And then If there is any rebuttal testimony that is to be given by the applicant, Mr. Baker, the applicant for the attorney, will have that opportunity. So it is an agenda item, and it's part of the agenda.
Okay. Considering that that there are materials that the board is reviewing, can we request that these are made available to the public?
It's my understanding that whatever materials that have been submitted are available to the public and have been.
Correct.
Are they available? Where are they available?
The board office.
Through Diane Ray.
The PowerPoint, is that what you're talking
The
about?
PowerPoint.
Yeah. I have
And
that.
can you explain, Mr. Thomas, why the rebuttal goes beyond the 3 minutes allotted in previous meetings?
Because of the fact this is a rather extensive application, and therefore the public, in an effort to make sure that there is no issue as to whether or not they have been given a full and complete opportunity, the 3-minute limit has been appropriately withdrawn, and therefore they have experts that have been testifying and will continue to testify tonight. So therefore, because of the extensive nature of the application, the public should have a reasonable opportunity to respond to the testimony that's been given by the applicant.
I don't recall the 3-minute limit being publicly withdrawn, or if.
For all intents and purposes, it was.
Was that implicit?
Implicit.
No, it wasn't. And,
Yes.
And you expect the public to understand.
Yes.
That's implicit.
I do.
When they've been told at every prior meeting that there is a 3-minute.
I don't
limit?
think we've actually stated every prior meeting
Or
that the
direct-
public
or-
only has 3 minutes.
I'm sorry,
It is
Madam
a sort
Chair.
of a
Or
discretionary.
direct cross-examination, or direct, or questions directed toward the very specific testimony of that evening.
I apologize. I'm not sure I understand that comment.
At previous meetings, those who wanted to ask questions were allowed to ask questions that were in specific response to testimony.
But
That
they weren't
is
limited,
correct.
and they weren't
They weren't
limited to
limited
3
in any
minutes,
way.
though.
Okay.
That's what I'm saying. There was no other limitation.
I stand
We've
corrected
set
about the
no
3 minutes,
limitation
but-
for
but,
anyone.
No, I'm just, it is a point of order, and since we have a camera here, and considering my role, I think it's very important to get this on the record. So thank you.
You're welcome.
Thank you. Okay, so
But I have a question. As long as you brought up, I guess, the issue of videotaping, who decides which meetings are videotaped? Is that something that the
I
town
have no
decides?
idea.
yeah, we weren't,
I mean, but who-
there's no request made. There's,
Yeah.
Gary Leslie, 501 South First. The answer is me. I'm the volunteer that runs the local access station. And I'm also a resident here, and people have been asking me to televise these meetings because they missed them, and they want to find out what's happening here. Does that answer your question?
It does, but I don't know whether, I don't know when the last time any meetings of this board have been
It's about 3 years ago.
for which application? I mean, I haven't been on the board in about 5 or 6 years.
I couldn't tell.
I mean, should we have our own policies or procedures with regard to
I'm not-
videotaping?
Just for your information, this is governed by the Open Public Meetings Act. You really don't have any say.
I'm just asking. I'm not saying they should.
No,
I'm just throwing out the question.
I'm trying to respond.
Mhm.
Okay? So I don't think you really can restrict it now.
I respectfully disagree. I think there can be reasonable restrictions, not to say that you cannot do it, but I think there can be reasonable restrictions placed upon it. Right now, I haven't seen anything other than this dialogue that makes the videotaping disruptive. And I think that I had talked about this with individual board members previously, and I had mentioned it to the chair, that if a meeting is going to be videotaped, either by this gentleman on behalf of some
HPTV.
HPTV, thank you, or by an individual, I think there are reasonable restrictions so that it is that the taping, whether it's video or audio, is not disruptive of the meeting. So in that sense, I think there are reasonable restrictions that can be imposed.
Right, and I'm not
Can I-
against the videotaping.
I'm sorry, this has nothing to do with videotaping. I need for the record just to reflect that Heather Wilkerson has joined the board. Okay, continue.
Not, as I said, I'm not against the videotaping, and I certainly understand the benefits of it. It just was something, kind of a surprise, because I just haven't recalled that having been done in my years on the planning board,
Right.
beforehand,
Our
and hadn't been done
meetings
before.
typically are not recorded in this
Right.
way, and I guess as being a board
And I may
member,
have
would
dressed
assume that
differently or
there
combed
would
my hair
at least
before I
be
left,
a
but-
request made or some sort of sharing of that request.
Two things. One is, we don't typically take these meetings because of resources. It's only when I get enough requests from people in the community that says, I want to be able to see this and I can't attend. Huh. Should I start over?
No.
Okay, so I think,
That's the reason.
okay, thank you.
I'm fine with my client is fine. So I just wanted to put in context for folks at home who may be watching that what you're seeing today is the objector's presentation. You've missed the applicant's presentation. So come back for next month and you'll see our rebuttal.
Alrighty, so we can have like a little ad for 7-Eleven. Get started here and move things along. We were about to hear from Ms. Monahan with the, I guess, your objectors, professionals.
Yes, thank you, Madam Chair. Good evening, everyone. Again, my name is Wanda Chin Monahan. I'm with the law firm of Sedita Campusano in Wayne. I do represent a small citizens group by the name of Highland Park Future. At last month's hearing, we began the direct testimony of James Constantine, a planner who's been retained by Highland Park Future, to provide our view of the applicant's request and the variances. The testimony and the cases so far has been presented to the board for their consideration. We have a couple of points that we just want to go back over, not to be repetitive, but really more by way of clarification. And one of those matters happens to be the 2010 amendment to the redevelopment plan. There was some questions and some confusion whether or not the exception to the redevelopment plan to allow a gas station to continue to be an acceptable use at this particular parcel, whether or not that exception was still valid, or whether or not there had been an amendment adopted in 2010 deleting that exception. So we'd like to start there if we might. Mr. Constantine, I remind you that you're continuing to testify under oath.
That is correct.
This morning.
The amendment that was adopted by the Borough Council in 2010 basically, as Wanda indicated, deleted the exception in the redevelopment plan that allows a gas station. And along with that then, driveways from Raritan Avenue, exposed parking, the public realm, and a freestanding sign at the corner. All of that was deleted, and very specifically, the last line of this amendment indicates that this property is subject to all of the provisions of the Highland Park redevelopment plan. So we'd like to clarify with that in light, because obviously there was some testimony that was really referencing back to that gas station and some of the physical characteristics of that site at the last meeting. And if we actually then revisit sort of the implications of that in the redevelopment plan, we'd like to call two provisions to attention that are in here in section 4A, and it's under the parking signs and maintenance. And there's two provisions about parking.
Mr. Constantine, I'm sorry, would you make reference to the page that you're referring to, please?
Okay, I'm sorry. In the redevelopment plan's page 16.
16?
16,
Thank
and
you.
it's the second and third bullets at the top of the page.
Thank you very much.
The first one reads, parking shall not be constructed between buildings and Raritan Avenue, or otherwise front on Raritan Avenue. I think that's pretty clear. Parking can't be on Raritan, can't be between the building, can't be along Raritan at all. Second, the primary access points to parking lots and facilities shall be from streets other than Raritan Avenue. Curb cuts across sidewalks along Raritan Avenue are discouraged and shall in no instance exceed 1 per block, or if only part of the Raritan Avenue edge of a block is included in the redevelopment area, 1 per such portion, located centrally to the block face. So it's limiting, as a goal, 1 driveway, 1 mid-block driveway per block, and trying to push it towards the center of the block face. It's absolutely clear.
And
So,
Mr. Constantine, your understanding of the word block as it's used in this part of the redevelopment plan, is it a city block as we know it, when you're get to the end of the sidewalk and then cross the street to the next block? Or is it the legal meaning of a block and lot parcel legal designation?
It would be a city block. I mean, it would be a block that's bounded by streets.
Okay. And currently, the block where this subject property is located, are there presently other curb cuts besides the one that is part of the former gas station site there?
Correct, there are several of them. But there is in the redevelopment plan an ideal intended mid-block driveway that's not on this site. It's a few lots in towards the center of the block, according
And
to that
do you
policy.
recall the testimony at the prior hearing of Mr. Paul Phillips, the planner, who testified on behalf of the applicant? I believe it was in response to a question that was posed by one of the board members in terms of his opinion as to what is the better location to have a curb cut. Is it closer to the intersection, or is it further away from the intersection? Do you recall that testimony?
I actually do not recall that testimony.
Okay. And in accordance with the provision here that you've just quoted, what was the preference that's expressed in the redevelopment plan? Closer to the intersection by the traffic light, or located centrally in the block face?
Located centrally in the block face. And I think there's a general agreement among planning and urban design professionals that that's safer. Most design guidelines attempt to keep driveways further from a corner, regardless of what the standard might be. As a general principle, you don't want to have cars entering the traffic flow near intersections.
And I'm sorry, Mr. Thomas, as a point of clarification, would you like the ordinance?
If you have a copy of it,
Yes.
does
I
it
think
make,
it could be
I'll take that.
O2.
Yeah, it would be O2. May I see it? Thank you. What's been presented, by the way, has Mr. Baker seen this?
Yes, I have a copy.
You do. What's been presented is Borough of Highland Park ordinance number 10- looks to me like 1785. It appears as though it was adopted on October the 6th of 2010. And it would be marked as O2.
Mr. Thomas, I believe the ordinance number is actually 10-1795. I know it's difficult to read on the
Thank you.
copy.
It's the best I could do. I'll take your modification. Thank you.
So in going back to those two provisions related to parking that I referenced in section 4A on page 16 of the redevelopment plan, I'd like to clarify from page 13 of the redevelopment plan, and this is all in the same chapter, Roman numeral 4A, land use regulation. It states in the second paragraph, quote, relief from provisions of this section, 4A, may be granted by the planning board in accordance with the provisions of section 70C of the municipal land use law. So these two parking provisions require relief as a C variance according to your redevelopment plan. And I do not believe that those were identified previously, either in testimony by the applicant or in any of their submitted documents or in Mr. Chektel's review. But we believe, we're just pointing to the redevelopment plan, it's saying that these need to meet the requirements of the C variance. So that means they need to meet the positive criteria and they need to meet the burden of the negative criteria. So they're heightened.
Mr. Constantine, let's turn for a moment to the positive criteria for the variances that are being requested in this particular application. Are there any conditions that are related to the size or the specific features of this particular piece of property that make the strict application of the regulations impracticable or result in a hardship?
I don't believe there are. You're going to see a plan presented that I presented last time that I worked on with Mr. James Nickel, who's an architect. We prepared an alternate plan that demonstrates that this site can be developed with the same size building. In fact, it can have additional building area. It can have parking. It can have a driveway, all of which meet the requirements of your code, your design guidelines, and your redevelopment plan. And that's always an important test. If you're going to somehow look at a site and make a case that it its hardship because of its uniqueness. This site can accommodate a development program that meets basically all of your design requirements, your redevelopment plan design requirements, and your zoning design requirements.
And just to be perfectly clear, Mr. Constantine, you're suggesting that that alternate plan that we presented at the last hearing, and we will present again through Mr. Nichols when it's his turn to testify, can be done without requiring any variances whatsoever?
There may be, as I testified last time, there may be a reduced variance related to the exposure of truck loading depending on where it occurs. And I think I also indicated there may be a reduced variance related to it's the loading from the parking area, the loading area not screened. But they are reduced from what they are today. But the variances for parking in front of the building, parking along Raritan, the variance for having a driveway that I just indicated out of the redevelopment plan, for the freestanding sign and some of the other ones that come along with that, but those are the key ones, would be eliminated. So you have the ability to take this site and develop conforming to your policies, your design guidelines, your requirements.
Right, and let's turn for a moment to the negative criteria for the variances. What's the test that must be met by the applicant here?
The test is that no variance or other relief may be granted unless such variance or other relief can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the zoning ordinance. And if we go first to the zoning ordinance for the CBD zone, section 230-140A, it includes, this again is the purpose of the CBD zone, to promote creation of a pedestrian-oriented commercial environment which encourages maximum pedestrian activity. So you need to weigh against that and make sure that that's not being impaired. Second, control vehicular intrusion into the CBD to only designated street rights-of-way and limit vehicular intrusion into pedestrian space by restricting vehicular curb cuts across sidewalk areas to the minimum extent possible. I think it's incredibly clear what has to be addressed without impairing the intent and purpose of the CBD zone. And there's one other, which is to promote aesthetically and visually harmonious development throughout the CBD. The general purposes of zoning are also referenced here, and I'm not going to go into them in detail, but I do think that it's worth noting that that the standards that I've just, or the purposes of the CBD zone that I've just mentioned, clearly are reinforcing the first purpose of zoning, which is to encourage municipal action to guide the appropriate use or development of all lands in the borough in a manner that will promote the public health and safety. Issues that go to the safety of pedestrians on the sidewalk, and the ability for citizens to feel confident walking down the street, not just go to the issues of safety there and the mid-block issues related to driveways, mid-block driveways related to the danger caused to bicyclists, which I'll talk about later in your master plan. But it also goes to public health, because a walkable community is a healthier community. There's been incredible attention paid to that. So it's one of those instances where the basic purpose of zoning, public health and safety, is right there before you as something that has to be addressed.
Mr. Constantine, what is your professional opinion as to the applicant's application compared to these negative criteria?
I believe that we haven't heard how the application won't impair the intent and purpose of the CBD zone, the provisions that I've just referenced. You have to rectify that, and that's the board's charge and the applicant's responsibility.
And how is the zoning related to the redevelopment plan?
Well, the redevelopment plan is very consistent with the zoning, in that it calls for a diverse Main Street where residents, visitors, businesses are able to, and I'm quoting, thrive in a safe, pedestrian-friendly, and ecologically conscious environment with the following characteristics: a public realm that focuses on human interaction, infill development that creates intimate places for people, a mix of ground floor retail services with offices and apartments above, integrated redevelopment that enhances street character, integrated landscape features that mitigate development impacts. The redevelopment plan wants to create a distinctive streetscape that reinforces the center of town, improves public safety, and enhances parking access from side streets. That's what it says. It wants to calm traffic along Raritan Avenue, thereby providing a more walkable, mixed-use environment that encourages local residents to leave their cars at home when using services along Raritan Avenue. And it also intends to create and extend rear parking lots where possible to minimize traffic flow across the Raritan Avenue sidewalks and to encourage shared parking. So you keep hearing again and again through the intent and purpose of the CBD zone and these policies that are contained within the redevelopment plan. There's a concern about the pedestrian realm, about public safety, about walkability, about where driveways should go on side streets and shouldn't go on Raritan, and the end result that you're intending to create.
So I just like to interrupt. We are familiar with our redevelopment plan, so if you could draw maybe some more specific, examples between the specific application at hand and, where you see specifically.
Sure. Well, I think if we go back and compare to the alternate plan that you will see presented in a little more detail shortly, and I presented last time, that it is possible to develop this site and meet all of these policies of the redevelopment plan appropriately, properly. You don't have to seek relief. You don't have to show that you're not impairing the intent and purpose, which I think the applicant needs to show, the board needs to find in order to grant this relief.
Mr. Costello, let's talk for a moment about one of the variances that really garnered a particular focus and attention in this application in these hearings, and that is the curb cut on Raritan Avenue. And in response to the question posed, let's talk for a moment about your opinion as to that proposed curb cut and how it either comports with or is at odds with the redevelopment plan.
Right. Well, let me backtrack. Start with the zoning. The zoning is very clear. It wants a pedestrian-oriented environment that maximizes pedestrian activity. Every curb cut breaks that. The intent of your CBD zoning wants to control vehicular intrusion to only designated street rights-of-way and limit intrusion into pedestrian space by restricting curb cuts across sidewalk areas. I think you have right there a violation, something you have to rectify against the intent of the zoning, which is very clear. And by the way, I've never seen a zoning ordinance that's so specific about driveways on Raritan Avenue, or on a main street before. When you actually go and look at the redevelopment plan and its goals to create a distinctive streetscape, to calm traffic, to provide a more walkable mixed-use environment, driveways on Raritan Avenue erode that, and it's very clear. And the redevelopment plan, and this is an important link, because I talked last time at the beginning of my testimony, and that we have a series of policies that I think really get heightened here and need to be addressed, that start in the master plan, flow into the zoning for the CBD, and flow into the redevelopment plan. And in the master plan, and I shared an exhibit last time, there was a lot of research and documentation done on circulation. Master plan was clearly focused on concerns of pedestrian safety and access problems. It identified that mid-block driveways close to road intersections contribute to the risk of both vehicular and bicycle accidents. That's right out of your master plan. I showed a map last time which indicated that the South 2nd and Raritan Avenue intersection was one of the most dangerous in town. It's documented in your master plan. The master plan states that this is partly a function of higher volumes along Raritan, but also the high volume of turning movements from intersecting roads and driveways. So that goes right to the heart of concerns about putting a driveway right next to a street corner. the master plan states, the numerous mid-block driveways along Raritan Avenue contribute to both vehicular and bicycle accidents. And it's specifically focused on the danger to bicyclists from those mid-block driveways, as I referenced before. In fact, it says that in particular they account for a major share of recent bike accidents in the borough. And that was at a point in time, but it's obviously identifiable enough. And then last, it also provides some suggestion for the solutions in the master plan. The linkage of parking areas behind land uses. It'd be terrific if every development application made some effort to do that in order to reduce the number and the intensity of mid-block driveways in the CBD. And then suggests other methods of access management along Raritan Avenue to try to reduce bicycle accidents, increase safety for pedestrians and bicyclists. Talks about the relocation and the reduction of driveways, coupled with the linking of parking areas through an alley approach behind the buildings, and providing road and intersection improvements to address the identified hotspots, which includes this intersection.
And in the applicant's proposed plan, without being granted the variance to allow the curb cut on Raritan Avenue, would there still be access into and out of the development?
Yes, it could occur from South 2nd Avenue, which is exactly what's called for in your zoning, in your design guidelines, and in your redevelopment plan.
And Mr. Constantine, can you think of any reason why they would need to have a second access on Raritan Avenue, this right in, right out, that's being proposed in the current application?
I'm not going to speculate on why somebody might think they need it. I think what you have to do when you're developing is look at what the regulations call for, look at the policies. And you have such a heightened concern about driveways in Raritan Avenue. I do find it surprising that somebody would propose one. Last, there's a whole series of design standards and guidelines for which there are some deviations or exceptions that are part of the package of this application. And last time there was a discussion about the fact that in the Highland Park ordinance, as in most ordinances, that the design standards are intended to be applied and interpreted with some flexibility. And I agreed with testimony from Mr. Phillips about that, because you have to have that new design. But it's worth going through section 23155, which is the section on modifications and exceptions. And there are 4 things that are laid out that must be met in order for the borough's guidelines and standards to be modified or accepted. And in fact, in 23155B, it indicates that an applicant must provide testimony that the resulting change will conform to all of the following. So let's look at what all of those are. The first is they must generally satisfy the purpose of this section on design standards and guidelines. And if we look at the purpose for the CBD districts, the design guidelines and standards are intended to give due consideration to the historic, physical, visual, and spatial character and scale of the area in which it's located. So you need to look at context. The other purpose of the design guidelines is that the standards is that they're intended to preserve and enhance the CBD's unique qualities, to reinforce its pedestrian circulation. There it is again. To guide and encourage new construction that is compatible with traditional form and scale. So that's you have to satisfy first the purpose of why these design guidelines and standards exist. The second test is that they be designed in accordance with the normally accepted borough practices for engineering, surveying, planning, landscaping, and architecture. So you could ask yourself, what is our standard for driveways are a great concern on Raritan Avenue? What's our normally accepted standards for that? And compare that to what's being proposed. The third test is, that again has to be met, is that this generally enhances the development plan or in any case, not have an adverse impact on the physical, visual, or spatial characteristics. So it's really asking and saying that the design guidelines and standards, and it says this up above in the prior section, are kind of the normative, the baseline. So you have to go from be from the normal standard or something that's you're able to look at and say enhances the plan and doesn't have an adverse impact. That test is there. And then last, an applicant has to show that the modifications or exceptions will generally enhance the streetscape and neighborhood. So it's enhance the streetscape or neighborhood, or in any case not have an adverse impact on the streetscape or neighborhood. So again, it's asking you to look at context relative to that, but it's asking you to look for something that's an enhancement and not having an adverse impact.
Mr. Constantine, what is your professional opinion as to the application that is before this board when you compare it to the criteria for seeing whether or not the guidelines are being met or are being controverted?
You know, if I look at just the last two criteria, I mean, there's no doubt that the condition that existed with the prior gas station was a worst-case scenario, with multiple driveways, the building pulled back, exposed parking, uncontrolled turning movements from all different directions. But when you look at what's proposed, I certainly can understand how anything, when you're starting with worse, could be seen as an improvement. But I really think what's proposed is going from worse to bad, because it's not meeting the intent of what you're looking for in all of your other policies. Buildings to the street, a safe pedestrian realm, not violating pedestrian space in the sidewalk with driveways, reinforcing the context of the traditional building forms. That, by the way, this is the linchpin block. You basically have a fairly intact main street, one block to the south towards the bridge. You have a fairly intact main street that comes into play in the block to the north. And this is the block that has more of the auto uses, more of the parking up front. So it's a critical block because although a lot of the character is challenge that's out there, you have clear policies which say what an enhancement is. And I don't think some shrubs or minimal improvements meets the test of enhancing the streetscape and neighborhood. And the neighborhood also means, lastly, that you take into account the fact that this is at the edge of a transition to a residential neighborhood. And so you have to also look at that test about pedestrianism. It's not just the commercial traffic that's up on Raritan, but it's thinking about the safety for the 8-year-old or the 80-year-old that lives a block or two away, or somebody that maybe lives 2 blocks away and doesn't move as fast. And those driveways need to be looked at in terms of how our most vulnerable members of the citizenry cross them, because an 8-year-old isn't perceptive about somebody who's pulling in fast to get a quick drink and get back on the road. 80-year-olds may be moving slower, their peripheral vision isn't the same. Somebody may be on a motorized device, parents may be pushing strollers. You need to be looking at that driveway on Raritan Avenue through the lens of safety for all of those people.
That concludes Mr. Constantine's testimony, and if board members, of course, have any questions.
Does anyone from the board have any questions for Heather?
Thank you for your testimony. It was very helpful. All of us are familiar with the redevelopment plan as well as the master plan, but this was very helpful to have it detailed and laid out for us, the points in particular that were in conflict. I'm relatively new to the planning board, I think just a couple of years, and this is a project that I got my feet wet on. And when I dove into it, I read the redevelopment plan. It was my first time going through point by point, and my reaction was very similar to what you're saying, that our hands are tied. There's no way we can let this go forward because this project just simply did not meet the criteria of the redevelopment plan and the master plan. And I guess my question is to you as a professional. If that is the case, and this is going to come across as slightly inflammatory, but it's also a real question out there. If that is the case, is there a process, since Highland Park put the redevelopment plan in place prior to the economic downturn, is there a process, because we all certainly, at least I personally, I have nothing against 7-Eleven. I would be happy to see it in Highland Park. I just think it's a hard sell to say it fits on this site, the way they have it designed. And it's a hard sell to say that it meets what Highland Park wants for their town. Is there a process, do you know, professionally, that you can, I don't even know what the legal term would be, to overturn the redevelopment plan? Because it would seem to me that that might be a process that would need to be looked at for this particular. Have you ever had that happen before in a township?
I'm not sure I understand what you're asking. You have the ability, the redevelopment plan can be rescinded.
But are you asking?
What I'm asking is we put together this redevelopment, and I know redevelopment is here, and they're going to speak to some issues, and maybe this, I'm saying this now to start them thinking about it. I do think our hands are tied, possibly, and from your testimony, it sounds like you think that our hands are tied on this one. Is there a process that townships can go through, given the fact that we adopted the redevelopment plan, we have a master plan, we have a zoning ordinance, that yes, we have leeway to vote however we want and interpret it how we want, but it seems pretty clear what the intent of those pieces were. I guess it is a rhetorical and inflammatory question, but is there a way to?
The answer to that question is yes, there's a way, but not part of this application
Not
process.
Okay. And I'm asking him if, in his experience, he's ever had that happen. No.
I guess the question, if I might, is, Mr. Constantine, in your experience, have you ever been involved in an application process where a variance was sought and the, quote, solution was the redevelopment agency or the governing body who has the authority over the redevelopment plan goes ahead and through the proper channels makes an amendment to the redevelopment plan, removing the objectionable requirement, so that now the current application before that planning board no longer requires the variance? Is that?
Yeah, that would sum it up pretty nicely.
Yeah, yes, I'm familiar with some situations where that's occurred, and also where standards have been tightened, where there was a recognition that the bar wasn't set high enough.
Right.
And was raised.
Okay. And in this case, we're saying lower the bar, right? But what you're saying is that that is not a part of this process.
What I'm saying is that there is a process, but it's not part of the application process. Okay. There certainly have been situations, I've been involved in many of them, when an application has been filed and there is a change to the zoning ordinance during the pendency of the application. In what was then known as the time of decision rule, the new ordinance then applied to the existing application. The time of decision rule no longer applies because it's been amended pursuant to, I believe it was a 2011 amendment to the municipal land use law. So what might have been done in the past no longer applies as part of this process.
You can't change the rules after the game is starting.
Okay. That answers that question, and I suppose never mind. It's not a question for him. It's a comment for later. Go ahead.
Anyone else from the board have any specific questions? I actually just would like a clarification. You were talking about mid-block curb cuts and driveways versus, initially when you're talking about it and you introduced the piece of the redevelopment plan, it sounded like you were comparing mid-block versus curb cut or driveway that would happen near a corner, right? So mid-block meaning towards the center of the block.
Correct.
Then you went on, and that it was safer. Now, is that in terms of vehicular safety or pedestrian safety?
I think it could be a combination of both.
So you're saying it would be safer to have a driveway mid-block where people are walking by a bunch of buildings and have a car
For instance,
egress in, egress out, in between tall buildings, then towards a corner where there's open visibility.
for instance, in this application, I mean, people can make right turns out of the driveway very close to the South Second intersection. That introduces conflict.
For cars, for vehicles.
For vehicles and for pedestrians. It introduces the potential for somebody to make an uncontrolled right-hand turn out when a pedestrian may be crossing across Raritan.
Okay, and then you went on to say that that these mid-block curb cuts and driveways cause more, I guess, vehicular and bicycle accidents. So in that, when you were referring to mid-block, did you mean any kind of curb cut within a block, or are you talking specifically about?
Your master plan, the master plan adopted by the planning board, is the one that identified that issue and raises it and talks about it in many sections throughout. So that was documented by.
And so your read on that that reference to mid-block there meant any curb cut or driveway within a block? Is that what you're saying?
The master plan basically indicated that there was a that they found. Give me a second here. It says the numerous mid-block driveways along Raritan Avenue contribute to both vehicular and bicycle accidents. In particular, they account for a major share of recent bike accidents in the borough. So that's in the 1997-2001 period is what they studied.
So we don't have a distinction as to whether they mean these more interior mid-block driveways versus something that happens closer to a corner? It's just sort of a generic reference. Okay.
Yeah.
That's the numerous. It seems like it's the numerous part that is also
the number
of
yes.
these curb cuts throughout. It just creates the confusion and conflicts. And at least that's my interpretation.
Yeah, I want to go back to the discussion you just had with Madam Chair regarding mid-block curb cuts, meaning curb cuts in the middle of the block versus towards the end of the block. So is it your testimony that you feel that a curb cut closer to a corner would be more dangerous than a curb cut mid-block?
It depends on how close to the corner. There is some relative distance that increases the potential conflict for, I think, particularly for exiting motorists heading into the intersection when they're not already in the stream of traffic. And again, what your zoning ordinance and your design guidelines and your redevelopment plan and your master plan says the preferred location is to get access from the side streets.
Yeah, I don't think anyone on this board is going to disagree with you that that is the preferred access
point.
points.
Clarification about if one were safer than the other as far as the location on any given block.
Because it would seem to me that if I'm walking in the middle of the block, I'm not expecting to have cars coming out at me as I'm walking. As I get towards the ends of the blocks where it's more open and I can see what's going on the corners, I have more of an expectation that there may be a curb cut there. And I think that's where this board may have been years back when the redevelopment plan was being put together, that if there was going to be a curb cut along this block, that the preference would be that it would be closer to the corner rather than somewhere in the middle. And I think that, as I said, ideally, I think all of us would love if the only curb cuts were from the sides. But that would mean that we would have a major developer who is now developing the entire block from first to second, or a major part of it, who's then going to be building parking from behind, and we'd be able to access from first and second. I think we'd all love that, and that's the picture that we have in our redevelopment plan. But I think at that time, we also recognize that that may not be the case, and that if there was going to be a curb cut, that being closer to South Second or maybe closer to South First would be preferable than having it somewhere in the middle. So I'm not saying I think that's just an issue in terms of where where our preference would be if there was going to be a curb cut. I think we all agree we wouldn't want to have one, but if we are going to have one, that may be, you know, the preference of the board. Again, I'm not speaking for the whole board.
All right, does anyone
Also,
else?
one other question. You mentioned on a few occasions that the applicant has not put forward testimony on certain negative or positive criteria. I mean, we were here for many months. Were you here at all the meetings?
I was not here.
Have you listened to all the tapes?
No, I didn't. I listened.
So how do you put forth your testimony that the applicant has or has not put on certain testimony?
I'm responding to the testimony I heard from their planner.
But that was only one meeting.
The last meeting.
Right, and Mr. Constantine, during Mr. Phillips' testimony, did he not go over all of the variances that were being sought in the application?
Yes.
Did Mr. Phillips also go over, you know, what his professional opinion was as to each of those variances and how they related to both positive and negative criteria? Did you listen to that testimony?
Yes.
Okay, I'm just making a point that there was plenty of other testimony, and you could have listened to all the tapes, you know, if you wanted to, and then make your opinion based on that. I mean, I think it's easy. I recognize and I agree with a lot of what you're saying, but it's very easy to start from scratch and put up a nice, pretty picture and say, oh, this is what it should be, because all you really had to do is put up a picture of our redevelopment plan, because that's what we would have liked to have seen, and you probably could have saved your clients a lot of money and just put that up and say this is what we would like to see. But unfortunately, that's not always the case. Let me also ask you, in terms of, in your experience with redevelopment plans in other towns, I assume you've had experience in dealing with them. Do you find that every application that's going before a board or or an agency or whoever has control over that redevelopment will meet all of the requirements of a redevelopment plan? Or will there be situations where you may meet some of the requirements but not all, or some of the intent but not all, and that the board may have given, or the agency may have given, some flexibility in terms of the positive elements, but recognize that we just can't meet them all?
And you're right. It's rare to see an application that, you know, meets everything. But I think it's really it's a weighing act that you have to go through, looking at the positive criteria and the negative criteria. How much has been, how much of your policies are being enacted, and how many are being missed, and weigh those against one another. So.
But specifically, Alan, I think that's an excellent question for this particular witness. Have you personally seen a redevelopment, you know, an application under redevelopment be accepted where there were no deviations from the redevelopment plan?
Or from, with regard to applications under regular zoning that go with a high level of design guidelines.
Well, I just mean specific to
conformity.
redevelopment. I mean, that certainly is an added level of different, you know, of different issues to justify, let's say, beyond the regular municipal code and a master plan.
Correct.
Can't hear you.
Oh, I'm sorry.
The more design criteria that's applied, you know, in different ways, it becomes a little more challenging to meet every single criteria.
Okay.
Mr. Constantine, just a quick question. Do you have the redevelopment plan in front of you?
I do.
Would you be kind enough to turn to page 55? Do you have that?
Yes, I do.
And that particular page makes reference to Block 13, which is the block that we're dealing with. Is that correct?
That's correct.
And it has a conceptual site plan for strategic infill and rehabilitation approach. Is that what that figure represents?
Correct.
Okay. What impact, if any, do you believe that has, given that the concept site plan does not include this property in regard to your testimony?
Well, it wasn't included at this time, but the action of the Borough Council in 2010 basically said apply the the plan and the guidelines to that site.
It certainly did in terms of the use, but does it have any, and I agree with that, does it have any impact in your opinion with regard to the other design standards, et cetera, that you have been testifying to?
Yes, I believe, and I actually have this, I can put it up as a slide if you need me to have it large for everyone to see. I believe there's actually, with a little proactive guidance and interplay, especially given the fact that the property next door, I think, went through land development approval either at this board or the zoning board during the past year, that there's an ability to try to get some cross-access easements and interconnect parking lots so that actually a driveway on South 2nd Avenue on the property in question with this application could interconnect to the property next door and begin to link into the rest of that plan.
Okay.
That's what, in my opinion, there's an opportunity to do.
Thank you.
Proactively.
Thank you.
Mr. Thomas, does the fact that in 2010, as it was properly stated, this area or what was on the conceptual plan was removed, right? Because
That's correct.
Was removed. Does that in any way give us, I don't know, I won't say a clean slate or a clean, more flexibility
Well,
in terms of what we want, what we feel would be appropriate, as opposed to, I mean, maybe. The board or council should have, instead of just taking that property out of the plan, or at least out of what was thought to be, what they wanted for that site, out of the plan, instead of just leaving it that the council or our board, maybe should have said what we would want to see instead. And the fact that that didn't happen, does that give us some latitude in terms of what we would want to see?
Well, that's why I asked my question. Clearly, the amendment in 2010 eliminated a use. I don't think there's any question about that, and I don't think there's any question about what the intent of that was. The question then, does that give you additional flexibility, given the fact that there was, at least perceived prior to 2010, the possibility that a gas station would either continue or in some way be rehabilitated? So you've heard the answer. That's why I asked the question of Mr. Constantine. I suspect if there's going to be an opportunity to ask that question of the applicant's planner, I'd like to hear his response as well. So I will, Alan, that's why the board ends up having to make these decisions. Hopefully you'll get some information from both sides to assist you in that regard. And I'll be happy to talk about that in some detail when we get to the conclusion of the matter.
Just want to ask a follow-up question, Mr. Thomas, to your line of questioning to Mr. Constantine. Mr. Constantine, that 2010 amendment to the redevelopment plan, removing the use of a gas station at that particular property, did it have any effect of removing the parcel itself out of the designated redevelopment area?
No.
So this parcel, this block 13, is still within a designated redevelopment area?
Correct.
Okay, and so is it your opinion that because it is still part of the designated redevelopment area, that all requirements and all limitations and things of the redevelopment plan are applicable to all parcels within the designated redevelopment area?
The last line of the Borough Council's amendment, this property is subject to all the provisions of the Highland Park redevelopment plan. I think that's pretty clear.
Thank you, Mr.
Okay, thank you.
Were you taking questions from the public cross-examination, Mr. Constantine?
I think that's appropriate.
Okay,
so that
instead of waiting
till
till the architect
exactly.
goes as well.
I think that's a good idea, and then
Okay.
possibly Mr. Baker may have some questions as well.
Okay.
Can I ask
Okay,
one more
so-
question, Kim? I'm sorry.
Yes, so
Just to follow up on my question before and on Kim's comments about whether in a redevelopment process it's typical to not meet all the requirements. And you said, yes, it is typical that a redevelopment really never meets all the requirements. There's always something that there's a variance or some exception made typically. Is that correct?
I think as you add more design guidelines in,
Right.
regardless of whether it's under regular zoning, whether it's under some sort of a design, my firm does a lot of work creating design guidelines, pattern books for the town architect or community architect for a number of different places and locations, and so you're oftentimes dealing with trade-offs in some of the design criteria.
Well, what I heard from your testimony today was that this particular application seems to not fit with the intent of either the master plan, the redevelopment plan, or the zoning. That seemed to be your testimony. In your experience, has a project or a redevelopment process gone through if the project at hand did not meet the intent of those governing documents? And is it typical for the development plans to be passed not meeting those criteria? I mean, not meeting, not the individual criteria, but the overall tone. I think it would be helpful for me, and I'm thinking maybe for others on the board, to know if it is not atypical to accept an application and a project that does not meet the intent of the redevelopment plan or does not meet the intent of the master plan. Can you answer that?
Yeah, I think it's, in my experience, and I guess my firm's experience as a reviewer, in looking at criteria and making a call, our experience is that there can be some minor design criteria that may be handling some trade-offs on, and sometimes it's very justified. This application is missing on some fundamental, absolutely fundamental issues, and it would be rare in a situation that is missing on this many fundamentals.
Okay.
Have you ever represented applicants or only municipalities, or as you said, as a reviewer?
Both, actually. Probably do a little more work for developers. And
as the applicant, is what you're saying?
As the applicant, we also serve, as I mentioned, as the community architect. For instance, we're the community architect at Celebration, the town that Disney Development initially started. And we are, just to give you a for instance, we are retained, even though Disney Development's been out for many years now, by the Homeowners Association. And there is probably a more critical homeowners association than people that have bought into the Disney brand.
Right, because I guess what I'm still struggling with is the issue of, the plan as a whole versus individual applications, and whether even have you ever been representing an applicant where your individual application may not meet all the criteria or even the intent, but if we're trying to as a whole, for the town as a whole, we're looking, to meet the intent, but there just may be some individual stores or applicants that may not meet all the criteria or the intent. And is in your opinion that every application would need to meet, the intent and the requirements of the redevelopment plan, or else you're throwing the redevelopment plan out the window?
I said last time that I agree with Mr. Phillips, and I think you need to have the flexibility in looking at things. I showed examples of 2 7-Elevens last time that appeared, I didn't have all the criteria and couldn't gather it, but appeared to have the same sort of walkability or lower than what you have here in Highland Park, the same sort of density or lower or less than what you have in Highland Park, which means it wouldn't meet the sort of the urban walk-up criteria, but there was some sort of a compromise that seemed to be made in those situations. One received the Mayor's Design Award in Denver, and the other one is part of a redevelopment district in Fort Worth, where there are very specific design guidelines that are being put into play. So I suspect those are places where things met somewhere and found a compromise. They both were examples of buildings that I think, to the degree of the way they related to the street, better meet your design criteria for the same use.
And if you had your choice, would you rather see this area be developed the way the applicant wants to, or left in the current state the way it is?
Nobody wants to see it left in the current state. I think that's, but I think I believe if the way it's proposed will undermine your development plan, your master plan, the intent and purpose of your zoning and your design guidelines.
Mr. Constantine, if the application were proposed with the alternate plan that we showed at the last hearing that Mr. Nichols will provide testimony on next, what would your opinion be then of that kind of an application where the building is pulled to the floor?
That you would basically have a conforming plan. There you may need a minor variance, less extreme than what being asked for here, and certainly several of them eliminated, and you would meet most of the design criteria, and you might need a guideline mark. So that the plan that you're about to see probably needs those, minor compromises, and demonstrates that the site can be developed to your code.
From a theoretical perspective, it can be. But let me go back to my comment about the current state versus what the applicant is proposing. Because it's easy for you in your position to come here and tell us that theoretically you could do it differently. But if the applicant isn't willing to do that, it may be easy for you to pack up your books and go on to your next project while the rest of us and our community is left with the current state. That is a possibility. You agree?
But is that our job as planners? I'm the planning board. Is that our job to determine whether we should take this because the lot will remain empty the rest of? Do we know that? Is that our job?
I'm throwing it out as just a possibility.
I think we have to look at this application on its own merits as a site plan review and whether or not it meets the criteria.
I guess I would just like to ask one follow-up question to conclude this. Mr. Constantine, in your opinion, do you believe that the property in its current condition, under the guidance of the redevelopment plan, the master plan, and the zoning, that there could be other interested developers for this particular parcel?
Let me maybe respond in this way. For those of us that are involved in real estate development, we have certainly been through a trying period, but I think everybody has seen that month by month things are ticking up. Redevelopment, parcels put out for redevelopment that did not receive bids 2 years ago, 3 years ago in the recession, are being seen in certain markets in a different light today. And I think everybody's pretty confident that month by month things are getting better and there's more and more opportunity. So I think you have to be careful about viewing the potential to redevelop what it's been for the past 2 or 3 years. It's been the worst anybody's seen. The next 2 or 3 years it's going to be more opportunities, increasing opportunities everywhere. That's where you are everywhere. It's in every professional conference, it's in publications, and it's across most of the sectors. I mean, single family is coming back in a number of different markets right now.
It's just coming to Okay, thank you. Okay, so are there any more board questions? And if not, then I would open the meeting up to the public. Now, just to be clear, this is just a time to ask a specific question of this professional, something that pertains to testimony that he's given. If there's anyone wishing to speak, please come to the microphone, state your name and address for the record, and ask your question. Okay, seeing no one, I will close the public portion part of for right now. And Ms. Monahan, are you going to
Yes,
have the architect also?
Yes, we'd like to swear in James Nichols at this point.
Okay.
Sir, do you swear the testimony that you're about to give will be the truth? So help you God. Would you state your name and the location of your professional office, please, for the record?
Yes. My name is James Nichols. I live at 232 Harrison Avenue, Highland Park, and I maintain a practice in Princeton, New Jersey, 245 Nassau Street.
Thank you. Maybe it would be easier if you, for you and everyone to sit at the table. Thank you. Sure.
Just because there are several stages, I guess, that we're trying to get through this evening, can you give us an idea of how much time you think you need for this portion?
I actually don't think it's going to be too long.
Okay.
I think we're going to try and focus on the small issues or the.
Okay.
It's really an example.
Okay, well, just be mindful, I guess, of the time. And okay, thank you.
Mr. Nichols, if you might, could you provide us, please, with a brief summary of your educational background?
Yes, I did undergraduate degree in liberal arts at Bowdoin College in Brunswick, Maine, and I attended Columbia University School of Architecture and received a Master's of Architecture in 1983. After graduating, or actually before, I began working for about the first 5 years in historic preservation in urban contexts, including South Street Seaport with the firm of Jan Pokorny Architects, which still exists in New York City. Since that time, I practiced in a wide range of areas, and also, in addition to practice, I held academic appointment at New Jersey Institute of Technology, and I also spent 4 years at the State Department of Education, where I focused on school facility planning and development.
Okay, Mr. Nichols, if you could just give us a brief summary of any professional licenses and work experience that you have.
Yes, I hold a license in architecture in New York and New Jersey, and I also have the LEED accreditation for any energy and environmental design. Apart from that.
And do you have experience testifying before boards such as this planning board?
Occasionally, in most of my practice in public schools, where it's really a courtesy. Public school projects are exempt from most local land use procedures. There is a what's called a courtesy review under the land use law that requires public notice of school project to the planning board, but it's not, most school projects are not subject to site plan review like this.
And have you ever reviewed, prepared, or assisted in preparing a site plan application such as the one before this board?
I have assisted on that, yes.
And Mr. Nichols, you mentioned that you are also a resident of Highland Park. Do you hold any positions, either appointed or volunteer positions within the community?
Well, I've for a long time, I've been in Highland Park since 1993, except for a 2-year break. And for most of that time, I was a member of what originally was the Design Review Committee, reviewing proposed improvements to commercial property in the Central Business District. That kind of has morphed into, currently I'm the chair of the design committee within Main Street Highland Park, and our committee is involved in administering grants for facade improvements, awnings and signage. We also, our most unbridled success is the planting program that has, every year planters are made beautiful by people on our committee.
And you say that this group is called Main Street Highland Park Business Improvement District. Does that include this Block 13, this parcel in question?
Generally, yes. Yes, yes.
And have you had an opportunity to review the site plan that's before this one?
Yes, I have.
And do you have you prepared an alternative plan for this?
Ms. Monahan, just a quick question. Mr. Nichols, do I understand that, maybe I just misunderstood, I just want to clarify it for the record. Do I understand that the bulk of your practice is involved in the design of schools? Is that what you do?
A significant portion, yes.
Okay. And what portion would that be? What would be that significant portion?
Probably 60%.
Okay. And the balance would be involved in what?
A range of commercial, residential.
Okay. Just so that the record's clear, unless there's any questions, either by Mr. Baker or any of the board members, I see no reason not to accept him as an architect qualified in that field. Mr. Baker?
No objection.
Thank you. Why don't you proceed?
Mr. Nichols, if you would be so kind as to walk us through some of the figures that you've prepared for this board's consideration.
Sure.
While he's doing that, are these part of a slideshow, or how, are we going to mark these?
We can mark them, Mr.
I think it's
Thomas.
appropriate.
They're
I
just,
actually have hard copy boards.
Good.
so we just thought-
and there are just 2 of them.
Okay, so the first one then we'll have identified as 03. And Mr. Nichols, if you could make reference to what that is, and if there's a date, I'd appreciate that.
Okay, I think we should use today's date. And this is, I'm going to call it Plan A, for want of a better term. And I guess find the right place to stand. I guess I wanted to say at the outset that this really is a theoretical exercise to test the idea of developing into this site with the 7-Eleven, putting the redevelopment plan as a primary success criteria, or a driver of the process instead of, and obviously we didn't interact with the client, except we had the application. So I think our goals were to adhere to the application as much as possible, but also be very mindful or put a priority on the goals of the redevelopment plan. And so we came up with a thing. Okay. So what we came up with is the site that we're all familiar with, and the 7-Eleven footprint and building is in terms of its area and general configuration, it's basically identical to what is in the application. So obviously, instead of being where the applicant has it here, we moved it to this far corner of the site. And that really is for what I'm going to call urbanistic reasons. To the corner of the site is the most important thing in defining the urban space. We have a second building located adjacent, also fronting along American Avenue. And the reason for that is, I mean, again, the redevelopment plan calls for, it's a very urban-oriented redevelopment plan. It calls for mixed use, and it calls really for, I think the limit is 75% lot coverage. So it's a very urban-oriented. So we have 2 buildings in addition to the same 7-Eleven building, we have this building here, which we're calling a studio loft space building, and that's another component of the redevelopment plan to encourage those kinds of special uses related to the arts. And I think it may even specifically call for flexibility in relation to that. So we have these, so those 2 buildings both tight to the Brereton Avenue street facade. No curb cut, obviously. The same access, ingress and egress, exact same dimensions that were shown in the application. We have, again, emphasis on mixed use, which is in the redevelopment plan. So both, this would have the opportunity for commercial space above, could be residential. This obviously is much more inherently mixed use.
Mr. Nichols, I'm just going to interrupt for 1 minute.
Sure.
Are you going to present an alternative, or is this the premise that you're working off of? Because Mr. Kluger just reminded me that there is a deed restriction on the
Yes.
table. So are you going
Right.
to address that?
We do,
or?
yes.
Okay. All right, then please continue.
That's Plan B.
Okay.
I have one before I go to Plan B I'd like to show, because I have an image. I mean, I guess let me finish what's here first. Lot coverage is 27%, well below the 75% max. I think it's slightly above, obviously, the application. Impervious cover is 87%, less than the 90% maximum specified. The redevelopment plan is looking for 33% residential use in this zone. This proposal has 24% residential use, and that's assuming just residential. It's basically 1/3 of the FAR. We have 15 on-site parking spaces, and we have a net gain of 2 parking spaces along the street. So it turns out the applicant is providing more parking on the site than is required by the redevelopment plan, which is a logical outcome of a more pedestrian-friendly redevelopment plan. Tend to provide less parking. I think the as-of-right requirement for parking spaces, at least for the retail use that we're proposing, would be 10 spaces on the site. So we're exceeding that. Obviously, if the residential were to happen, we'd have to deal with residential parking.
Right. And Mr. Nichols, how does this plan compare to the applicant's plan? First, beginning with the size of the retail building that you have shown there. The square footage, for instance, is it the same, less, or more than in the proposed application?
It's a teeny bit more. I think it's within 20 square feet.
And what about the number of parking spaces? How does it compare to the proposed plan before the board?
I believe it's quite similar to
Right. Right. My recollection also was that the present application calls for 15 parking spaces. I think that your testimony said that by your ultimate plan here, you would actually gain 2 additional on-street, on Raritan Avenue parking spaces because of the elimination of the curb cut there. Is that correct?
Right. Yep. Okay. That's basically that. I do have do have an image of this, of Plan A. I don't have that. I have it on this board, so. You can see one last picture. So just, here's obviously the 7-Eleven building. This would be the adjacent building. And these are extremely conceptual. Obviously, again, it's not an application, so it's really a concept. Now, the one issue that arose at the last meeting was this 40-foot setback. So Plan B takes a similar approach, but maintains the historical 40-foot setback along 2nd Avenue, which was apparently provided in the 19th century for stables along 2nd Avenue. And I'm not really gonna, the attorneys can comment on the legitimacy of that, but, it turns out it's a pretty nice feature of the urban space on 2nd Avenue, and I know that, I didn't even realize it until this whole proceeding, but this, the BB Big building adheres to that setback, and I think most of the houses do. And it turns out that the upside of this, it pointed out another real benefit of this approach and the deficit of the application is that the side wall, BB Big sits right here, and its side facade will be quite visible, extremely prominent from Raritan. So, but anyway, the point is, this is actually a really, the result here, it's very similar to the other one, exact same 7-Eleven building. Smaller in terms of footprint and gross area. The studio loft building is smaller. That other, Plan A had 3 units, and the idea of these would be that it's kind of a new economy idea where the, I've worked often on my career. Okay. Work at a home but artists, craftsmen, people that in the new economy, the blend between work and home life is low. So this supports that. This building requires a variance for the 10-foot side yard setback that exists in the current zone. So that's one additional variance that would be triggered by adhering to this older 40-foot setback. Otherwise, there is a loss, I think. This one has 11 parking spaces on site, down from the 15 shown previously. Otherwise, it's exactly the same.
Before you proceed, Mr. Nichols, I'd like to just keep up. What I believe we should do is mark your rendered Plan A as as 04, and then your Plan B on your projection as 05. And then do you have a rendered Plan B?
I don't have it.
Okay, so we're up to 05.
Mr. Nichols, you testified that the adjacent user there is conforming to the setback. Are you aware of whether or not the existing Sunoco gas station building similarly conforms to the 40-foot setback unit restriction?
I am aware that it does not. It's built right to the, basically right to the property line, as opposed to. So, I guess the only other, I think the only other comment I would make about this in general is that the parking, this would say a lot of places that exist in Highland Park, the parking is pretty generously designed in terms of room to back in and out of the spaces.
In a safe manner.
In a safe manner, and I think although I'm sure a driver of a semi-trailer delivering to the site would have a hard time. I think there's a pretty good feature of the, a good feature of the 7-Eleven plan was this kind of a pretty good K-turn ability right in there that would make it pretty easy for most of the delivery trucks that probably would service this scale and this kind of retail.
Thank you, Mr. Nichols. That concludes this testimony. I can take questions.
Okay. Does the board have any questions for Mr. Nichols at this time?
Mr. Nichols, if you'll have a seat. Thank you.
Could we have further clarification on the deed restriction?
Probably not by Mr. Nichols.
By anyone?
Not at this point. I'm sure there's going to be, and at the conclusion of this case, hopefully we will have some clarification. But I'm afraid, Mr. Williams, it's not possible either through this witness or at this time.
No? Okay.
I have.
Yeah. Alan, go ahead.
Go ahead.
Mr. Linares?
Yeah, I think this is a question for Ms. Monahan or your witnesses. Let me preface it by saying that I know several members of the redevelopment agency. And I happen to know the chair personally. And I find him and others to be intelligent, articulate, thought-provoking, and contemplative. And based on the testimonies you provided, can you offer an opinion as to how they got it so wrong?
Well, that's not Ms. Monahan's job.
I don't want to put the locals on the spot, but maybe you can, or maybe Mr. Nichols can.
Certainly, you know, we all know the same people. I mean, it has nothing to do with any. I really think it's a matter of procedure and perspective. If you and it's really like what this exercise I think illustrates. If you start with a user or a client or a developer who says, "Here's my goals, A, B, C. I want this to happen," that's a much different point of view, and it's going to lead to a different result than proceeding in the opposite direction. I think the idea of in my view, professionally, the idea of the redevelopment plan is to take the longest possible view and set the longest possible term goals in terms of viability of the retail district and of the community in the long term. And that becomes this touchstone that, like Ms. Wilkerson was saying, how do we decide? Nothing ever fits that perfect view. But it's always, there's always an upside to a redevelopment project that's weighed against the cost, the downside, the little curb cuts or whatever it is. And curb cuts are a small one, but it's a balancing act, and I think that's the way things are weighed. A typical redevelopment plan would be an incredible upside to a community that's justified, that justifies some massaging of the implementing details. And the other thing is, there's always conflicts when you go to implement something that's written in an abstract framework, theoretical. When you go to actually apply it to a specific case, there's always going to be friction. And that's why.
Maybe Mr. Constantine could offer his opinion as well?
Can you come back?
Do we have to?
He's got to come out.
If you as the chair say it's okay.
It just seems to me that you've provided. Okay.
I would like you not to, frankly, Ms. Monahan, you are not a witness. This is a question, and you're not being, unless you would like to be sworn and be qualified in some way, shape, or form other than an attorney, a summation will be provided if you feel as though that's appropriate at the appropriate time, but not in response to a question.
And I'm sorry, so Mr. Linares, are you also requesting that Mr. Constantine address that directly, or
Yes,
give perspective on how
if you
these
could, I
different
mean,
plans?
he's provided in his, we've had several alternatives. 2 from Mr. Nichols, several from Mr. Constantine. And it seems to me that our redevelopment agency put years into this decision. And certainly it seems to me, knowing the people that I know on the committee, on the redevelopment agency, that they would have come to the same conclusions you did. So I'm confused as why they're so different.
Well, I can't speculate in terms of
Right.
what, but I can tell you this: working, working oftentimes on behalf of, I'll call it in what we refer to internally as the vision keeper role. That is, we are the community architect or the lead design firm in charge with implementing. A lot of times you'll start with a site and they'll be back and forth, and you'll try to work with users. And I will tell you that some of the master plan developers that are effectively in the role of the redevelopment agency here will work, and sometimes they'll push national tenants. They'll find out where they can go in terms of negotiating. If fits aren't right, sometimes it's not the right applicant for the right location. In other cases, sometimes people will come in, but they'll be willing to abide by rules. I showed numerous examples last time of pharmacies pulled to the street, which you don't normally see. I showed a CVS pharmacy in Baldwin Park in the city of Orlando's model smart growth community that we designed that has housing above on 2 levels. It's pulled up to the street corner. It is a CVS pharmacy. It has a drive-in, but it's tucked back behind. You don't see it from the street. It's probably not where the pharmacy would have started, but that was the vision set by the city in their redevelopment plan and pushed forward by the master developer. But it wasn't easy to get there, to get into that higher order form. That takes work.
Thank you.
And have you always gotten to where you wanted to be in representing a town?
Sometimes you're not successful, but it oftentimes starts by exploring design options and opportunities and trying to work back from there. I think
Okay.
I have a few questions for Mr. Nichols. I
Yeah,
applaud.
no, I'm sorry.
Oh, I'm sorry. Did I go ahead and somebody else?
No, I just want to make sure that the board
Right.
asks their questions. to Mr.
I
Nichols.
certainly, applaud, this option in the way you brought, more, building frontage, to Raritan Avenue. And you were able to take the curb cut off of Raritan Avenue, because obviously, I don't think anyone could disagree that that's not a benefit. But I guess one of the other benefits you have is that your plan hasn't gone through a review by our professionals to make sure that it works. Like, for example, it'd be great if all the traffic is going to come into this site from South 2nd Avenue, but we don't have the benefit of a traffic study to see what that's going to do to South 2nd, only having one entrance and exit out of this site. Because as the applicant had stated during their testimony, that they felt one of their benefits was that the traffic would be at a mix between those using South 2nd and those using Raritan Avenue. And I agree that the preference would be for all, the traffic to come in from South 2nd, but we don't know how much. And it's easy also to pick a studio or loft space as your second building, because that probably has the minimal amount of activity that will require parking and cause traffic and other issues like that. So again, from a theoretical perspective, I don't have any issues with what you're presenting. I'm dealing more from a practical perspective of, you have to find the perfect applicant who would want to do this exactly, the way you want. I mean, I don't know if the objectors are ready to write a check to the applicant to pay for the building of the second building. Maybe, talk with them. Maybe they'd be willing to do that. And then you can go find the perfect tenant to be this studio and loft space. You're certainly welcome to do that. But I think this is still, it's very good from a theoretical perspective, and my concern is where we're going to be from a practical perspective.
And I can certainly appreciate that. I think that part of Mr. Nichols' charge in preparing these diagrams, frankly, was in response to some questions, particularly by Ms. Wilkerson, of the applicants' professionals who testified to, did you try to reconfigure the site, and did you try to pull the building, and can you show us what configurations you considered, but dismissed for whatever reasons, and give us your reasons. I don't believe that that was ever fully responded to by the applicant, other than to say, we did try, and this is the only plan we could come up with.
Right, and I agree with you. I also want to hear from the applicant as to why they think this can't work, at least with respect to this 7-Eleven building.
Yes.
Maybe not, with respect to the secondary building, that's a hypothetical, and very theoretical as to whether that's going to happen. And I think what the applicant had said was, one was the deed restriction, and two, there were some issues with the turning radius or the ability to get in and out of the parking lot on South 2nd if the building was moved closer to South 2nd. So I think I'm looking forward to hearing from the applicant as to what their responses would be.
Could I just answer your question about the vehicle access a little bit? Because I think it points to what I understand an interesting dilemma for this site and for Highland Park, which is really that it's my understanding that 7-Eleven has a model of urban criteria for an urban 7-Eleven, and they have a suburban, vehicular-driven model for their operations. And Highland Park falls kind of between those two parameters. And so in some ways, it goes back to the question of what's the role of a master plan, what's the role of the board, which is which direction do you want to go? You could choose a project that will lead you towards more vehicular use, less pedestrian use, or push a project that goes towards more pedestrian use.
Mr. Nichols, I'm sorry, go ahead.
Agree with that. I think one of the questions I had asked at one of the earlier meetings is whether 7-Eleven or the applicant had done any type of study to determine what their expected customer mix would be between walking patrons versus vehicular patrons, and also those that live within Highland Park versus those that may live outside of Highland Park, and that may impact how much parking you need, or whether you need both curb cuts, and how much traffic there would be. Unfortunately, that study wasn't done, and that was the response, but I think that I agree that that is a concern, and that is an issue.
Mr. Nichols, could you just refresh my recollection on Plan A? How many parking spaces does your plan include?
It has 15 on site.
Including the spaces in front, you mean?
I showed those as a separate.
Do you have paper copies, the 8.5 by 11 for us to be looking at?
I can get them.
Oh, okay.
I don't.
So there's 15 on site for Plan A, and then there's additional parking on the street. Is that what you're saying?
Yes, we calculated that we'd have a net gain of 2 on-street parking spaces from what's there.
And with the plan that you propose, including the, and I gather the loft space, as I understand your testimony, is residential loft space. That's the intent?
The intent certainly is that there would be some residential use there, because that's what the master plan.
Okay. So what you're showing over on your render drawing is, which is 04, is a 2-story second building loft, and it's a footprint of, I thought I saw 1,400 square feet, something like that. That's B.
That's 2,000 square.
2,000. So you're proposing the residential up on top, and then a commercial activity on the first floor?
Right.
Okay. Does that combination does your parking analysis satisfy that combination of the 7-Eleven on the one building and the residential and commercial in the second building?
Well, what I can tell you is that the commercial parking requirement would be 9.5 spaces, so I guess you could have 10 for the area that's there.
Meaning for
So-
the 7-Eleven?
For the 7-Eleven, and actually it's for all the retail on the ground floor in Plan A.
In both buildings?
In both buildings.
Okay.
Would require 10 parking spaces.
And what about the second floor in each? What would that require, assuming that one is residential, the other's office?
You know, I can't really speak to it. I mean, in terms of the specific requirements, but I'm not going to misrepresent it. But so I expect there would be at least one parking space required for residential.
And what about the parking that's, I'm sorry, finish.
So the office space, I don't know. So if you add all the 15 on-site and the 4 off-site, you'd have 19. I think we're doing pretty well by way of parking.
Okay.
Right, because
And
your testimony, I'm sorry, your testimony, Mr. Nichols, is that for the retail that's in Plan A and in the concept, it would require 10 spaces, and you said that there would be 19 spaces total, so that would allow 9 additional spaces to satisfy whatever the parking requirement might be for that second use of residential space.
I don't see there being enough parking for that. I mean,
Being enough parking?
yeah, I'm just saying is that without knowing, I mean, it's tough to throw something out at us, it's not being reviewed, and then we don't know whether it really can work. Because I'll give you an example. That parking setup with the parking spaces going back is going back to the old Dunkin' Donuts parking situation that we had, where everyone had to kind of drive in, pull into your spot, and then to get out, you had to back up to get out. You end up going down to the back, not knowing do you have spots or you don't have spots. Again, conceptually, where the buildings are, that's great. That's absolutely great. But if the rest of it doesn't work, it's tough to say, oh, this is what the applicant should do.
And that's why I introduced this at the beginning. This is not an application, it's really a concept plan.
And with regard to Plan B, Mr. Nichols, how many parking spaces are proposed on site for that plan?
11 on site, 4 on the street.
Yeah, but you're missing the handicap spot, so you lose one.
Actually, there are 2 handicap spots there. The striping.
Well, I'm
next to
counting,
the-
I'm counting 11 spots. I don't know where you're getting the extra spots.
So,
Yeah, the ones that are there are handicapped.
I don't think so.
So we could say
Well-
there are fewer parking spots than
Clearly.
Plan A.
yeah.
The striping didn't print out, actually. Here's a curb cut, 2 handicap spaces.
And
I included the handicap spaces in the, and I'm assuming that that's the way it works, that you have a total parking requirement and then the handicap is part of that total requirement.
And with regard to that number, given the 2 buildings that you have, can you tell us whether or not you have done an analysis as to whether or not the parking works for that proposal?
Well, but, by the same thing, I think, I haven't done, I didn't really analyze the residential.
Okay.
I really looked at the commercial. Again, the one thing I'd point
And
out
the- and the
about
office
this,
on the second
I
floor.
think that's why, quite honestly, what motivates the designation of Artist Loft as the program is that it's my understanding the redevelopment plan has language that specifically encourages that kind of use and suggests flexibility relative to the specific requirements. And I think that's a really good example of the appropriate basis for a variance when the major goal of the redevelopment plan is being advanced. Variances are appropriately granted to support the big goal.
And last,
But
Vice versa.
variances sometimes are granted also for the needs of the applicant.
Right.
Okay.
No,
So for example, I mean, in this plan, have you taken into account, we had a couple of months of testimony from the applicant on what their business needs are, whether you agree with them or not?
No,
Were
I'm
you
sensitive.
here to listen to that testimony?
I wasn't, and I'm certainly
Okay.
sensitive to their needs,
Right.
and that's why one of our key procedural assumptions in this was to stick as much as possible to what was in their application.
One final group of questions. Your proposal, both Plan A and B, includes 2 buildings, whereas the applicant proposes 1, correct? Is there a reason why you chose to have 2 buildings on the site?
Well, it really gets back to the redevelopment plan, intensity of use.
Okay.
It's a very urban density that's specified in the
All right.
redevelopment plan.
And do each of these buildings represent a singular principal use, in your opinion?
I think they're distinct, if that's the question you're asking.
Are they distinct principal uses on in each building, in your opinion, as an architect?
Versus mixed use? I guess I would see the whole development as a mixed use.
Okay, thank you.
And are you asking why there's 2 separate buildings versus making that one development with divided into more than one storefront? Is that
Partly.
Yeah, well, I think,
in other words, it could have been constructed as one long facade, the way infill is supposed to be happening as part of the redevelopment plan without that alley in between.
right. I think the alleyway, muse, whatever you want to call it, the motivation for that really was to provide convenient pedestrian access from the parking to the front entry of the building, because one of the inherent problems in
Right,
this...
so you're not walking through a parking lot.
Right, and you're not, I mean, the way this building plan would probably work is that the stair and access to the second story would be at that exposed corner near the parking. There would be a possibility for a secondary entrance from into the 7-Eleven, but generally retailers don't like that. And certainly, again, if this were a real project, there's a lot of really good ways to attack this, but it's a tricky problem. I mean, it's a prominent corner. It'd be nice with a prominent corner entrance, but again, without a client to say, well, what's important to you, that's...
Okay.
I have another question, or maybe a comment also from Mr. Constantine, maybe could answer as well. Have you ever seen where a project like this maybe could be done in phases, where you may, or a situation where you may have one applicant, he only wants to build one building, but maybe you leave space in the plan for someone else to come along later to build the second building? Because I think obviously, ideally, we'd like one large developer to come and do the whole block and be able to take care of the parking in the back and more frontage on Raritan. But have you ever seen your experience, or you think it could work, that something could get approved as phase 1 and something else can come along as phase 2?
Yes, I think you can have a phased development. I think it can work. It's more challenging at a small scale like this, but I think it comes back fundamentally to the driveway from Raritan. I think that becomes effectively probably a deal breaker in terms of the physical form and making that work.
Okay, does anyone else from the board have questions for Mr. Nichols at this time?
I just want a clarification for myself. So it seems to me, Mr. Nichols, that what you've done is shown us that, contrary to what the applicant, I think, has told us, that the site is developable with a 7-Eleven with the same footprint in a different configuration than they've shown us. It is not possibly developable in a manner that fits their business needs, but it is developable. And so, as I understand it, then our task is to decide whether their business needs outweigh our needs as a town and our requirements as outlined in the redevelopment plan and the master plan. Am I right? Okay, simple question.
Totally feel
Okay,
simple
well,
question.
that's
Your
the- that can
diagrams
be your- that
basically
can be your
show
answer.
that the site is developable with a building of the same footprint in a different location.
Although it may not.
Although it may not fit their building,
No,
their
no.
business needs.
No, but I'm going to disagree with the point in terms of it's on paper, where the buildings are located may be developable, but what we don't know is we don't have the details of traffic, of circulation, of parking, to know that it can be developed
The plan
and
hasn't been
meet our
vetted to
codes.
know, even with the different.
Yes, I understand.
We don't know that it can meet our codes,
But
or
I
that it
will
can
say
meet this
that that
plan.
was a risk that the applicant took. It was, these concerns were brought up at the very beginning, and it was a risk that they took by not giving us that information and saying the only way we can do it is with the curb cut on Raritan Avenue. So we don't have that information, and I don't think that onus is on Mr. Nichols or his respective witnesses.
Right, because the board
So-
could still say, because you don't meet the redevelopment
Right.
plan requirements, we can say, I'm not going to the legal side yet, but could deny it based on the fact that it doesn't meet the plan. But all I'm saying is that what they have proposed, there's no guarantee that it actually meets our development code and our zoning rules for us to be able to say, sure, you could have done this. And forget about business needs. I'm just talking about whether something could have been
Right, but
developed
so for a
meeting our
process,
needs.
though, I think it really was on the client or the applicant's shoulders to show us that they absolutely can't do this.
Well,
Because this
but-
meets our
but
redevelopment
The thing
plan.
is, it was brought up before.
Pardon?
That design is the old Dunkin' Donuts, which did not work. That whole
That parking
area
is
the old
straight
Dunkin'
from their
Donuts
site
to a
plan. That parking is straight from their site
That parking is in
plan.
the applicant's site plan, the exact same configuration.
No, it's not.
Not
No, it's not.
not
That's
all
nothing
of
like
it.
the
Some of
applicant's
it, some of it. It has some of those
Well,
features.
the back
The parking
area
we're talking
is
about
the
in back
same,
is exactly what.
and the parking in the building.
Yeah, but you're missing the whole other link.
Right, no, I know the curb cut's not there, that's really a big part of what this is. But
Okay.
that configuration back there with the dead end and all that is in the application.
Okay, is the board satisfied that we can open for some public questions, or? Yes. Okay, so at this time, we'll open the meeting for any public questions specifically for Mr. Nichols regarding testimony that he's given. If you care to speak, please come to the microphone and again, give your name and address.
Could you identify yourself, please, for the record?
Alex Kemeny, 35 North 6th Avenue, Highland Park.
Your question for Mr. Nichols.
Yes. Looking at, I guess, the first design that you had, you called it Design A, you indicated that there were some additional parking spots that would be on Raritan Avenue. That would
be helpful. Thanks.
I'm gonna see if you may be outing me on one revision that didn't make it to this.
I'm taking a look at the spots that you have there. Those lines, those indicate spaces between parking spots?
Those are
demarcations of.
parking spaces.
Okay.
Are you talking about the street parking or
On
in the
streets-
parking lot?
On the street
On
parking.
street, right.
On street. Okay. You don't have any space between every other
Yes, yeah.
parking spot, do you?
You win the prize. You win the door prize.
So.
But they also didn't calculate those spaces in, it's just not drawn on the plan. They're not calculated into the number.
That was pointed out to me afterwards. I actually live close enough to Barrington Avenue that I often walk between the shop. So there's, so there you go, the two spaces in the X.
That's already been, oh,
That is-
I'm sorry, you're right. That plan, it's been pointed out to me that that plan that you just showed the public and the board has not been marked, I gather?
Oh,
That plan?
yes.
Right, it's this.
06.
It's really that except with those.
But it has the numbers.
Yeah.
But we should,
Why don't we mark that one as 06? And that becomes what? There you go.
It turns off.
Hopefully I'm on now.
Yeah, just like.
And Mr. Nichols, when you mark that, what, that is Plan A, is that correct?
no, that was Plan B.
Or Plan B? Oh, that's right, I'm sorry, yes.
Your microphone is red again, just,
You have to hold that button in for a couple seconds.
thank you.
All right, so, just so I'm clear, 06 then is the hard copy of Plan B. Thank you.
Is there a hard copy of Plan A that has the demarcations of the unusable spots, or however you might want to refer to them?
Shall I mark it or something?
Didn't we
Yes.
write that one initially?
Well,
Wasn't that the first one?
No, that was all.
Exact thing, it's just the parking.
Does that reduce the net gain of the 2 parking
The
spots?
parking that I reported was accurate. It's just the graphics.
So that's 07. Would you mark that, please?
Plan A, 07.
Correct.
Right, so the calculation was correct, they just didn't put the X's on the drawing, okay.
Just a couple more questions, if you don't mind. You've testified before planning boards, zoning boards in the past. You've represented a variety of different clients. You've represented a variety of different clients that have requested variances as part of their site applications?
Probably not. I've not represented an applicant particularly for variance.
Might have a question for Mr. Constantine, but I realized that he was up before, so I don't know if I can ask him just
I'm
2-3
comfortable
questions.
with you asking your question to Mr. Constantine.
Thank you very much. Mr. Constantine, have you represented any applicants before, any planning boards or zoning boards that have requested a variance?
Yes.
And some of those applicants say that were before planning boards like this planning board. Did they request a variance as part of a site plan application, even though another buildable use was available on that lot without a variance? Was that a clear question?
No, the question was clear. There have been bulk C variances as part of site plans.
So that's a yes?
That's a yes.
Okay. So some of the clients that you've had in the past had a piece of property in which they were looking to develop and could have built on those lots without requesting a variance, but still requested that variance.
Yes.
Were you successful in those applications when you testified on behalf of those applicants, or at least some of them? You testify well. I'm sure that you must have been successful a few times.
Sure, at least some.
Okay. So the test then is not whether you can build some form of building, or that there's some permitted use that could be developed on the lot without a variance, but the test is really that negative and positive criteria that you were speaking about before?
Yes, let me answer more fully the question that you were asking. I've actually, on behalf of applicants, we've sought variances where I believe, and the board decided, that the end design, actually the positive criteria, the public benefits, perhaps creating better streetscape, the building at the right location, was met. And so therefore, that was part of, really, I would call it a better design solution. We were designing a better design solution than what the code said as a bar. Sometimes the code sets, we found an inappropriate design solution. Sometimes the policies, the plans haven't caught up to it.
So while that's not your testimony in this application, it could be a professional's opinion of this application that it meets the criteria, or not the criteria, but rather the purposes of the Redevelopment Act, this particular plan?
I'm not going to speculate on that.
Okay. Thank you.
Okay, thank you. Is there anyone else from the public wishing to ask a direct question at this time? Okay, seeing no one, I will close the public portion of questioning for Mr. Nichols. So now.
Ms. Monahan, do I understand that you have some lay witnesses that are part of your organization or your group?
Yes, that's correct. At my first appearance before this board representing
How many do you have tonight?
I believe we have 5 here, and each of them have comments that are individual to their particular interests that go to different portions of the application before you.
I understand. The concern is, of course, some time limit with regard to lay witnesses, and I think that's appropriate. That's number one. We need to discuss that. Number two, what I am concerned about, and you and I had this discussion earlier today or yesterday, I can't remember now, about making sure that the testimony that's being provided by your witnesses is not redundant and repetitive. So I want you to be aware of that fact, and I think...
I can represent to Mr. Thomas that in conformance with the discussions that we had yesterday, that I've gone over the testimony for each member of this Highland Park Future Group, and I've made certain that there won't be any repetition in terms of their testimony. They are covering different interests from each of their perspectives, and there may be some overlap perhaps, but it will not be repetitive.
Mm-hmm.
All right, so thank you. We'll keep you to that representation, and hopefully we can do each one of them within the time frame of 2 minutes each, not more than 2 minutes each. Right.
We'll do our best to...
Thank you. Mr. Thomas?
Yes.
I thought we had a discussion very early on, the fact that if they are represented by counsel, that according to our rules, they don't have the ability to speak.
No, they have the right to speak, but they need to speak in conjunction with their counsel. In other words, what I don't want to have happen is that Ms. Monahan now sits back and her group, her clients, start coming up uncontrolled. They need to be as part of her testimony, and they identified as such, and they are late. They have the right to speak, just as the example that I had given earlier to someone was that just as the 7-Eleven people who were employees of that company talked about certain things, members of the public have the right to do that as well. My concern is that we get into some redundant and repetitive testimony by these individuals, and that they are not controlled by Ms. Monahan.
Right, so the language in our rules that say such parties shall participate in the proceeding only through counsel.
Correct.
So this is
She's
the
through
only
her
through
counsel. Correct.
Okay.
Thank you.
Good.
Okay, thank you.
Thank you, Mr. Thomas. I'd like to first call Jenny Chapman.
She provides her.
Do you swear do you swear the testimony that you're about to give will be the truth, so help you God?
I do.
Would you state your name and address, please, for the record?
My name is Jennifer Chapman, and I live at 123 Magnolia Street.
Thank you.
Ms. Chapman, how long have you been a resident of Highland Park?
Since 2001.
And do you have a family in Highland Park?
I do.
Okay, and could you tell us?
I have 2 children and a husband. I have a sister and a nephew in town, and actually another sister and her husband in town.
And the ages of your children?
10 and 7.
And Ms. Chapman, do you work outside of the home?
I do.
Okay.
Yeah.
And what is your position?
I own 2 businesses in Highland Park.
Okay. Could you identify those businesses?
Over the Moon Toys and Through the Moon Gate.
Okay, and are you a member of Highland Park Future?
I am.
And have you attended the prior hearings before the planning board on this application?
Yes, I have.
And have you listened to the testimony that's been provided both by the applicant and also by our expert witnesses?
Yes, I have.
And so it's safe to say then that you're familiar with the site plan application that's before this board?
Yes, I am.
And if you might, in quick fashion, summary fashion, tell us and tell the board what is your interest in this proceeding?
I'm going to read this so that it's quick. I'm here as a mother and as a resident. I'm concerned about the safety of my children. I live a block away from this property. But also I want to represent the perspective of a member of Highland Park's business community. Where to locate your business is one of the biggest decisions any business person makes. Business districts market themselves to target markets in the same way a business does. Paramus is the land of big malls. Ocean City is where you take the family. Route 18 is where you go for strip mall stores. Traditional pedestrian downtowns are themselves a specific kind of business model and is what our redevelopment plan was modeled after. My business is predicated on a certain number of people who will get out of their cars and stroll around town. The reason that towns have master plans and regulate their business districts is so that the business owners can have predictability when they make their business investments. An obvious example of this is that no owner of a funky toy store or a hip new coffee shop would ever locate next to a spot that was owned for landfall or toxic waste dump in the future. It makes no sense. And that's what zoning does. It protects us. It is the business plan for the whole business district. And it constitutes a contract between the town and the business community. The town makes it clear through the zoning and planning what kind of a place they want to be, and we make our business investments accordingly. I decided with my business partners to invest in this downtown partly because the redevelopment plan and the Main Street organization promised a walking, shopping, dining downtown that would draw people here, much in the same way that Lambertville and Princeton do. I just moved into a newly renovated building, reinvesting in Highland Park's downtown. Like dozens of people who have invested their life savings into Highland Park businesses, the ones that are here chose to be here because of the walkable attributes we have. They didn't invest in Edison or Route 1 or Route 18. They wanted to be in a strip mall area, they would have located there in the first place. 7-Eleven has every right to move to Highland Park, but if they want to be in the central business district, they need to play by the same set of rules that everyone else does. The idea that a strip mall style development might be constructed not at the fringe of town but right in the middle of town is beyond comprehension to me. If you approve this site plan, you'll be breaking your own rules in a way that specifically gives this one business an unfair competitive advantage over the coffee shops and convenience stores existing already in town, meanwhile poisoning the well for the existing businesses that rely on pedestrians. If we want to have a successful business community, we have to have a clear vision for the town, a business plan for the business district, and we have to stick to it. We can't just randomly make decisions just because a particular developer wants something. We must think of the whole business district, not just one business. We just came through the worst recession in living memory that brought new development to a standstill, and just as we're heading into recovery, we shouldn't throw out our business plan to the first convenience store that comes along. The folks from the 7-Eleven have repeatedly reminded us that in days gone by, we've made the mistake of allowing large parking lots in front of the businesses, making it more difficult for pedestrians, and ugly signage on poles and what have you. Frankly, I don't appreciate being reminded of mistakes from years gone by as I work to improve myself, and neither do the citizens of Highland Park. We love our town, and we're improving our downtown. Reminding us again and again of the past, in this case, is a dirty, mean trick, and we won't be fooled. It would reflect poorly on this board and on the borough for these variances to be awarded when existing businesses continue to invest here and send the wrong message to potential new businesses and developers if we should cave on our ideals and move so drastically from the master plan.
Ms. Chapman, would you
Thank you.
consider...
Actually, she's gone like
I'm sorry,
over, but because she had a prepared statement, I thought it was reasonable to allot
Thank you.
that time.
I just want to just ask one follow-up question of Ms. Chapman. Would you consider the two businesses that you own in town to be competitive businesses to the 7-Eleven that's being proposed here?
Not really. No.
Thanks.
Can I ask you a quick question?
Yeah.
You mentioned Main Street, and it just thought of that. Has Main Street reviewed this application? Are you a member of Main Street?
I am. I'm on the board. Yes, and I volunteer.
They have not had any comment?
No formal, the board has not, in any setting, approved this.
Well, that's, okay, so that's her testimony.
That's
so
your
we'll have
testimony.
to accept that, and then we can
I
get further information.
99.9% of all the meetings, and we never sat down and discussed this and
Thank you.
decided whether or not we would.
Okay.
Okay. So your next witness, please.
Are there other questions?
Mr. Baker, any questions? Mr. Baker, any questions?
Do you have any questions? For?
I have no questions.
Thank you.
Okay.
I have a question, Kim. Hi, Jenny. Have you ever had a chance to express your feelings to the redevelopment agency?
No, I found out about this project when it came out in the paper, and I was told that it probably would not go through because of our great redevelopment plan. And then I got a letter in the mail from the planning board about a year later, and that's
Because you live within.
and I wasn't.
You were
I didn't know of
noticed.
any-
Is that what you're saying?
I live within 200 feet of it. Yeah. So, no, I have not. I would love to speak to them anytime.
Thank you.
And are you taking questions from the public?
If there are any members of the public that have questions of her, doesn't seem to be. Thank you very much.
I'd like to ask Mr. Rob Roslowicz to speak next.
Sir, do you swear the testimony that you're about to give will be the truth, so help you God?
I do.
Would you state your name and address, please, for the record?
Rob Roslevich, 123 Magnolia Street.
Would you be kind enough to spell your last name?
Roslewicz.
Thank you.
Rob, how long have you been a resident of Highland Park?
10 or 11 years.
And are you Ms. Chapman's husband?
I am.
So I won't go through family issues again. And Rob, do you hold any positions within Highland Park, either appointed or volunteer positions?
Not now.
Okay. And do you work?
Yes, I do.
Okay, and can you just briefly tell us what your occupation is?
I'm a New York State registered landscape architect. Right now I work construction project management. In the past I was in design and construction aspects of landscape architecture in New York, working on major projects, the Route 9A reconstruction project, Hudson River Park, Brooklyn Bridge Park, and then also a number of roadway realignment projects for the New York City DOT.
And the testimony that you're about to provide to the board is not in any professional capacity, is that correct?
That's correct.
And have you attended the prior planning board meetings on this particular application?
I have.
Okay. And you've listened to the prior testimony of the witnesses as well as our own expert witnesses?
I have.
Okay. And you're familiar with the site plan application that is before this board?
I am.
Okay. And if you would just briefly, again, in summary fashion, tell us what your interest is in this proceeding and application.
My interest in it is I'm within 200 feet of the property, and
That is, you live within 200 feet of this property?
Within 200 feet of this property. I was part of the charrette for the redevelopment plan, and when I saw it come up, I felt like it didn't meet the intent of the redevelopment plan, and I thought that New Highland Park could do better. And then I also have a prepared statement, if I may. One of the things that has come up is about whether or not this project could increase the tax revenues and the tax base for the town. One of the things right now is that the current property owner is paying the taxes. They are current on their taxes, and this application is actually for a smaller development than the current existing gas station, or the previous use of the gas station. So one of the things that they were talking about is whether or not it would be an increase, but it's actually more so.
Who is talking about ratables and taxes?
Because we haven't talked about
That
here,
I don't
though.
believe that's an issue before our board,
For
and
the
it's
board
not
to
something that we
consider as part of
would
the
be
application.
Okay.
addressing.
You know what? Then I would go on to the other point where being within 200 feet of it, and the idea that we could have a drive-up development where you look at institute studies where Brookings Institute, when you have a walk-up sort of community, you have an increase in the percent of the
Madam Chair, are
value
these
of-
facts before us that we?
I'm trying to get to the part of what he's even saying.
Oh, okay. Well,
Before
according to the 2012 Brookings Institute study, a 22% increase in walkability translates into an 80% increase in retail sales, $301 value per square foot premium in residential rents, $81 per square foot premium in residential housing values. So that would.
And your point of this is, the translation is?
The translation is, if this was developed properly, I would see an increase in the value of my house and an increase in the value of the sales of my wife's store, both of which would be a benefit to myself. Whereas with the looking at it the other way with what's been proposed, I don't see it working.
Okay, thank you.
So as long as you're admitting this is testimony is about your personal benefit as opposed to the town as a whole.
No, I believe that.
At least that part of your testimony.
No.
Okay, you just said it would put more money in your wife's store. So.
And you know what?
She's
it
a
would put
business
more
in
money
Highland
into
Park.
the entire
I understand.
Yeah. All the stores. All the stores.
Okay.
I think there's a benefit to all of it. But then the developers also stated that the development will make the site safer and that the existing curb cuts and traffic safety. However, that's also false. Right now the site has been declared abandoned. The New Jersey DOT would look at that as the opportunity to review all of the permits for the site. Right now, the way the site is, you can lay down on the sidewalk and there's no danger to you. If it was built out the way they want it to be built out, there'd be a curb cut within 26 feet of the intersection, which is against the New Jersey DOT guidelines. And on my own behalf, I have approached New Jersey DOT with an appeal for the access permit that was granted to them, and they'll be making a judgment sometime in January as to whether or not they feel the the access permit should be denied.
But you understand that there has been a permit issued?
There has been a permit issued
Thank
by
you.
New Jersey
Right.
DOT
The
and state
DOT.
guidelines. It can be appealed.
I understand.
Right.
Yeah.
But they have
They
issued
have
it.
sought out
At least
the
at this
waiver
point.
from DOT for where their curb cuts are.
Yes,
Okay,
and
so
based
again,
on
we've gone
that,
way
I have
over
to-
our allotted time, so if we want to.
Thank you very much.
Thank you.
I have a question for Rob.
Oh, I'm sorry, yes.
Rob, have you ever had an opportunity to express your feelings in front of the redevelopment agency?
No.
Thanks.
I'd also
Anyone
ask,
else
just
have a
for
question
our
for-
next speakers, I mean, it seems to me these are issues of people putting almost expert testimony or trying to put expert testimony on the record. So is that
Well,
something that?
if I can answer the
That's fine.
question.
I don't have a problem with it, but I just think we have a process for it. I'm just asking the attorney.
I did not believe, at least in my opinion, that the first testimony was in any way expert. I will be instructing the board with regard to some references to a study, and I will advise you ultimately that that is not something for your consideration, since we don't have any information about the study, and you have not had the opportunity, and more importantly, the applicant has not had the opportunity to cross-examine anybody about that study. So I'm going to be instructing you accordingly that that portion of the testimony dealing with the study is not relevant.
Mr. Baker?
I was going to ask for that instruction. So.
Okay.
May I make one comment, though?
Not on that study.
No, not on the study. No. One of the things that came about at the beginning of this, when we chose to go with council, was that we would, council would ask questions, and we would, everything would go through her. However, at that time, it was also that at the end, we would be able to speak as a portion of the public. Now that, I agree with you. I think it works to everyone's favor that we're doing it this way through council. So our comments do incorporate some of the things that we would have said in that public portion, because right now this is our only time to speak.
Because Mr. Thomas has also instructed that members of Highland Park Future will not be allowed to make public comments when other
Outside of
members
this
the
form,
public-
right, okay, and we've established that through,
And the
and
reason
Mr.
is real
Baker
simple,
accepted that.
so that it's on the record, the reason is real simple, because they are giving their public comments now.
Right.
Yes.
Thank you very much. Next
Okay.
witness.
Jeffrey Aaron, please.
Sir, do you swear the testimony that you're about to give will be the truth, so help you God? Would you, I'm sorry, thank you very much. So would you state your name and address, please?
Jeffrey Aaron, A-A-R-O-N.
Thank you, Mr. And your address?
240 South Adelaide Avenue.
Thank you, sir.
Mr. Aaron, how long have you been a resident of Highland Park?
I've been a resident for 40 years.
Okay, and do you have family in town?
My wife is there. I have a daughter in town also, and 2 grandchildren by way of that daughter.
Okay, and Mr. Aaron, do you currently work?
Well, I am retired from a wholesale plumbing supply, a large plumbing supply, Aaron and Company, which is based in New Brunswick. And in my retirement, I'm the sole owner and manager of a real estate holding company, Front Porch Realty LLC, that holds a multi-family building in Highland Park and a multi-use building in Highland Park, a real multi-use building in Highland Park.
Mr. Aaron, are you a member of Highland Park Future?
Yes, I am.
And have you attended the previous planning board hearings on this particular application?
Yes, I have.
And did you listen to the prior testimony provided by the applicant as well as by our expert witnesses?
Yes, I did.
Okay. And so you're familiar with the site plan application that's before this board?
Yes.
Okay. And if you could briefly summarize for us, Mr. Aaron, what your interest in this proceeding is?
Well, my interest is as a longtime resident of the area, resident of Highland Park with family, and I anticipate being here for the rest of my life. And I'm in sync with the redevelopment plans, and I would like to see the development to be as appropriate as possible for my family and my future.
And Mr. Aaron, if there are any other comments you'd like to make, now is the time to make them.
Okay. Very briefly, a reason that I have heard to justify the granting of all these variances for a plan that is grossly out of sync with our own downtown CBD redevelopment plan is that we have not had other offers despite the length of time the site has been available. So we should take what we can get at this point. I believe that this is erroneous thinking. Despite the history, there is no doubt in my mind that we can do far better for the following reasons. The site became available in 2009 at the height of the economic downturn, the worst time for development for almost any location during the lives of most likely everyone present here tonight, and during the time the Redevelopment Authority was considering this plan. That time is coming to an end, according to the recent analysis of the National Association of Realtors Commercial Market Study. And I do have the citation if you would like it. I don't know if that can be submitted or but it is available. The economy is coming back. Wall Street forecasts call for $55 billion in total private label commercial issuance in 2013, up about $11 billion or 24% from the expected 2012 total of $44.4 billion. And I have citations for this. With ongoing expansion of Rutgers now, thanks in part to the recent state public bonding for construction, plus the implementation of the New Jersey Medical and Health Sciences Education Restructuring Act, and benefits related to joining the Big Ten, such as admission to the prestigious Committee on Institutional Cooperation, there will be growth in the entire New Brunswick-Highland Park area, which has already begun. This will raise all boats as far as jobs and development are concerned, and there are few good small retail sites such as this in our built-up region. As a narrow but nevertheless excellent building site location, a prime location, it is likely to be well developed soon in this recovering economy. And even if it is not, we do receive tax revenues from the current owner. So there's no urgency to accept an inferior proposal forever. Forever. As a landlord who rents largely to Rutgers graduate students, staff, and faculty, a true multi-use building on that site could accommodate such good residential facilities on the second floor or even a third floor. Unlike the proposed building, which is not truly multi-use, with the exterior floor access stairway coming from the 7-Eleven kitchen and no separate exterior access. As a progressive landlord, I almost never have vacancies. It is not worth contravening our own redevelopment plan with so many variances that undercut our downtown essentially forever, simply because some people are impatient for the site to be developed. These variances will make this an inferior proposal that should be rejected, there being no hardships that require these variances. It is worth the wait, and the wait is not likely to be long. Why permit a developer who was unwilling to bend to meet our development plan, instead permitting vehicle cuts through our sidewalks, the installation of a large ugly monument sign, and a large parking area on the street front? This developer is even unwilling to bend about building signage specifications and lighting. We can do better.
Thank you, Mr. Aaron.
Okay.
Question?
I want to ask my question again. Have you ever had an opportunity to express your feelings in front of the redevelopment agency?
I haven't, because it wasn't well known that this was being considered, and it became
There
evident
were
to me afterward.
multiple public meetings. The plan has been available for almost 2 years now, the actual agreement. So I don't, it's been, we're what now in our 7th or 6th?
Well, he doesn't have to defend that he hasn't seen it.
No, I'm saying, but we're up to our 6th applicant, and not one of them knows anything about the agreement.
Does that make their comments irrelevant? I don't understand the point of those questions.
They keep bringing up the redevelopment. They keep bringing up the redevelopment plan. They don't, nobody says anything about the redevelopment agreement.
Well, as I said, it was being considered during the worst point of this economic downturn. I'm aware of that fact.
Paul, did he satisfy your, I didn't,
Yes.
okay,
Yes,
thank you.
thank
Does anyone else have a question?
Any questions from the public? None seen? Thank you very much, Mr. Aaron.
And we had 2 additional members, and now I'm being told that we're just going to present as our last witness, Randy Solomon. And if we could just give him just a little bit of leeway, because we are trying to...
Like we'll give him 4 minutes?
Yes.
Okay.
Sir, this swear the testimony that you're about to give will be the truth, so help you God.
I do.
Would you state your name and address, please, for the record?
My name is Randy Solomon. I live on 331 Felton Avenue in Highland Park.
Thank you.
Okay. And, Mr. Solomon, how long have you been a resident of Highland Park?
Since 2008, I became a homeowner. I also lived in Highland Park for 2 years in the mid-90s.
And do you have family in town?
I'm married. I have 2 children who attend schools here. I also have a brother-in-law and nephew and niece.
And how old are your children?
6 and 3.
Okay, and do they attend school in town?
The 6-year-old in Irving School and the 3-year-old in Montessori.
Mr. Solomon, do you work? What is your occupation?
I direct a think and do tank at the College of New Jersey that focuses on land use and sustainable development. And I've consulted in both public and private around the world and extensively in New Jersey. I wrote the Middlesex County Sustainability Plan. I actually was the lead author for Highland Park's Green Community Plan, which was ratified by Borough Council in 2007.
Mr. Solomon, are you a member of the Highland Park Futures Group?
I am.
And do you now, or have you ever held any positions within Highland Park, either on an appointed basis or on a volunteer basis?
In the mid-'90s, I served on the Environmental Commission, and I was a former chair and current member of Sustainable Highland Park, and I was recently appointed to the Redevelopment Agency.
Mr. Solomon, have you attended the prior hearings before this planning board on this application?
Yes.
Okay. And have you listened to the testimony of the witnesses that have been presented during these proceedings?
Yes.
Okay. And the testimony from your fellow members of Highland Park Future that you've just listened to, do you agree with their comments?
Absolutely. I thought Jenny Chapman in particular was very compelling.
Okay. And Mr. Solomon, if you could briefly again summarize what your interest in this proceeding is.
And this is lay testimony. This is not being proffered as any kind of.
That's correct.
Thank you.
Yep. I'm just an interested resident who wants to live in a sustainable green town and have safe kids and a vibrant business district.
Okay. Mr. Solomon, if you could just again briefly summarize the nature of your comments.
Well, I have a prepared statement. When you told us we had 2 minutes, I busily started crossing stuff out.
Thank you for that.
Thank you.
But I'm going to try to stick to it as best I can, given the fact that you can see.
Okay.
I've made concessions. Right? That's what this is all about, is trying to find a happy middle ground.
Thank you.
We've been talking a lot about pedestrian safety and quality of life. These can be esoteric terms. I'm not talking as an expert. I wanted to bring this back down to earth by relating a lot of this to my real life experience of living in this town. When we walk in the nice walkable parts of town, me and my family, the kids run up ahead, the whole operation stretches out, everyone relaxes, and we feel comfortable. When we walk down by Raceway or in other parts of the town, we're dodging curb cuts, everybody gets unrelaxed. It's like, hey, stop, kids, come closer. We tighten up, we're not happy, we don't want to be there. We don't linger. When we're in parts of the town that are nice, we do linger, we socialize. And one anecdote related to that is that when Jem's Galleria opened up in town, we immediately checked it out. We do it with every store in town. We didn't like it, frankly. We didn't see anything there that was good for us. But months later, we were hanging out in front of town, hanging out, which is what downtowns are about. And our daughter saw something that she liked in the window. She saw a little jewelry box. And we bought it, and we went back inside, we gave it a second look, and now we've shopped there many times since. Their inventory has rotated. And that is the economic promise of downtowns. That's how it's supposed to work, and that's not an accident. That is why it's designed that way. And I could cite you lots of studies, but apparently I can't cite you lots of studies. But that is common planning practice, and that is why that is in the plan. The people who wrote that plan actually were vetting a lot of these planning concepts, and that's why they are in the plan. So what exactly contributes to walkability? Well, according to these studies that I can't cite, and according to our own planning documents, Highland Park's planning documents, it's buildings that orient to the sidewalk, it's safety, it's preventing cars from intruding on the sidewalk, it's creating clear, defined spaces, the outdoor walls, and the psychology of placemaking. And that's everything that's embodied in this plan, and that's part of the business plan for the town. And every little decision adds up. Changing a town is a generational activity. We didn't get to this point overnight. The patchwork that we see in Highland Park is the result of the history of the town. And we're not going to reverse that overnight, but we have to start somewhere. So as a community, we made a clear decision that we wanted to go this way towards a walkable, sustainable, green, healthy town, not that way towards Edison, that way. I don't know where Edison is. And we created a plan at great cost of time and money that gave us the zoning rules and the authority to actually make that happen. We can, unlike a lot of towns, we can actually enforce and achieve our vision. And this is our first opportunity in a long, long time where we get to choose. Are we heading this way or that way? So I want to give you another practical example, again, from my life, of the nuts and bolts impact of these building design principles and why they actually matter, why this is not some esoteric stuff that, you know, people might like. And the principle I want to illustrate is, this is a quote from Highland Park's design guidelines, and it says, buildings shall be located to front and relate to public streets, not oriented to front towards a parking lot. Why does that matter? I want to compare this development to the Dunkin' Donuts development, the new one, not the old one. It's a development that has some similarities to the proposed 7-Eleven. I'd argue due to its location in the middle of town and not on the skirts of town and on a corner, the 7-Eleven is much worse. But to make a point, let's look at Dunkin' Donuts. It's a building that's got 5 businesses in it. Dunkin' Donuts is on the corner, and it's got 4 other businesses next to it. I've been to Dunkin' Donuts hundreds of times to get my coffee in the morning as I drive out of town to go to work. I cannot, for the life of me, tell you what those other 4 stores are. I go into the parking lot. The building is oriented towards me in the parking lot. I go into Dunkin' Donuts. I come back out. I get in my car, and I leave. I will never probably go to those stores. I just don't know what they are. And that, again, is part of what a walkable community is. Compare that to Jim's Galleria, where not only did I investigate it, but it got a second and a third chance. So that's part of what being a walkable community is all about. Not only will the 7-Eleven not bring people onto the streets, it'll create a roadblock. It'll create a no-go zone where I'm not going to want to go with my children. So, for example, Jack's Hardware, should it remain there, I probably won't be hanging out in front of Jack's Hardware and saying, oh, you know what, my hammer broke. I'm going to run in there instead of going to Home Depot. It's just not going to happen. That'll be another area of town that's cut off to me and my family, and that will slow down the economy. That'll be counter to our business plan. So again, all the stuff that's in the redevelopment plan, all the stuff that's in the master plan, it's not an accident. It's not BS. It's real. There's a reason for it. Finally, I want to note what's the downside of saying no to this development. If we're worried that this is the best we can ever get, I want to put your mind at ease. If in 3-4 years of trying to get new development, we decide that a strip mall is in fact the best we can get, believe me, we can always change our zoning and allow anyone who wants to build a parking lot and a big monument sign and a big curb cut, and we can get any chain store and any little dinky convenience store we want. Not a problem. This is not a once-in-a-lifetime opportunity. What is a once-in-a-lifetime opportunity, though? Well, let me put it the other way. If we approve this, though, once that curb cut goes in, once 7-Eleven owns the property and they are there, you can no longer then evict them. You can't change your mind. We're going to have that curb cut. We're going to have that anchor strip mall-style store in the middle of our downtown for 30 years. And that's what they testify to. They expect to be here for at least 30 years. Finally, I want to say I really sympathize with all of you, and I respect you. This is a small town. It's a fishbowl. Sometimes it feels like high school. Everybody knows everybody, and however you vote, somebody's going to be mad, whether it's friends or neighbors. In some cases, other agencies of the town are going to be mad at you. You can't make everyone happy here. The one thing you can do is you can let this decision rest on the spirit and the letter of the rules and the planning documents of Highland Park. That's all you've got. And that document, more than anything else, you've asked about public process and who got a chance to have input. The things that people have the most input to are those documents by design. And those are the best embodiment of the desires and the spirit and the intent of the people of this town. We don't want curb cuts. We don't want cars. We want walking. The variances requested by the applicant will decrease pedestrian safety, undercut the vitality of the business district, and it adds little in terms of value for the town. It doesn't add tax revenue. And it trades one eyesore for another eyesore. And it will not add safety because right now you could go and lie down in front of Sunoco. You could lie down and you could play checkers and you will be safe. And so I'd rather have a safe chain link fence where I can hang out to and be safe as I walk by it than a convenience store that's not safe and I won't walk by it anymore. So they don't meet the test for negative criteria, in my non-expert opinion. But before, as a government body, you can even move to consider the impact of granting the variance on things like safety of our kids. The rules say that the applicant has to establish a hardship. These are the negative criteria. And throughout these proceedings, the applicant has said again and again that they can't conform. They tried, They said the site's too small, too compromised to do it any other way. They said that even, you asked Mr. Kluger if it had been vetted. If they had really tried to look at this, a design like this, they could have done the traffic studies on a design like this. What they want, essentially, is they want a competitive advantage over the existing businesses. They want to come here and they want to beat out Park Deli. Park Deli would conform to our redevelopment plan. It's exactly what we want. It's on the street. It orients to the street. And I'm sure if Park Deli could have their own parking lot right out front and their own monument sign and their own private drive off Raritan Avenue, they would love to have that. That would probably help their business. But it's your job to set the rules and make sure everyone competes on the same terms. And so 7-Eleven's doing exactly what they want. They want an enshrined competitive advantage over everybody else. But that is not a hardship. Their business plan is not our hardship.
Okay.
Thank you.
Wait, Mr. Solomon, there may be questions from Mr. Linares.
Yes,
for example.
well, just as a point of fact, 7-Eleven is a tenant, as I understand it. They will not own the property.
That's a technicality.
Well, and certainly, Randy, you have had to have an opportunity to express your feelings in front of the redevelopment agency.
Well, it's interesting. I got wind of this, and I talked to. I didn't have any experience with the redevelopment agency at the time. I talked to Mayor Minkoff about it, and I talked to Steve Nolan about it, and I expressed my opinions on it. And I asked, what's the deal? The last time I talked to Mayor Minkoff about it was quite a while ago when he was newly inaugurated, and he said he thought it was kind of dead, wasn't going anywhere. So I wasn't paying much attention. And I'm sort of assumed that in a town like Highland Park that you get a chance to weigh in before big decisions. Everyone here is above board. Everyone's trying to do the right thing. So you assume that you're going to get your chance to weigh in. I think the planning board has procedures like noticing people within 200 feet of the development and saying that there's a public hearing and you should show up at a certain time and place, that people understand that this is your time to come weigh in. I think the redevelopment agency, being newer, doesn't have the same kind of procedures. The way they noticed it is they have an agenda. They publish the agenda. On the agenda is one item that says, consideration of Sunoco development. But that's not sending the same signal to everyone in town that, hey, folks, here's your chance to weigh in. Whereas the planning board does, and that's why everyone is showing up now. And I think that's something that, in the future for the redevelopment agency, we could consider changing. These are just procedures, and again, no one's at fault. It's just an unfortunate circumstance.
Certainly, when Randy, when you spoke to the mayor, it was prior to the final approval from redevelopment.
Right. The next I heard of it was when everyone else heard of it when the planning board noticed it. So I thought it was.
But you were aware of it prior to redevelopment approving it.
I did, and I tried, and I reached out to my elected officials and told them what I thought about it, and sort of made it clear that I would like to be included in the process. And then the next I heard about it was when it got noticed.
But then never made it to the redevelopment agency's meetings.
No, but again, yeah. I mean,
Thank you.
I wish I had.
So,
can I ask a quick question following up on Paul's question too? Clarification. When you talked about the strip mall development, and you obviously didn't like the strip mall development, you were referring, as I understand it, you were referring to the site plan and not the business. So whether it's 7-Eleven or whoever it happens to be in that building is not what you're objecting to. It's the strip mall site plan development, the physicality of it, not the business, right?
That's correct. And actually, I have been doing a lot of consulting in Taiwan recently, and 7-Eleven's a Taiwanese company, and 7-Eleven is like the neighborhood store in Taiwan. It's the laundromat, the grocery store, the cash checking, and they're on every street corner, and they're integrated into the fabric of the cities, And Jim Constantine showed 7-Elevens all over the country that integrate themselves into the fabric, into the business model, if you will, of the places where they are. So I would welcome a 7-Eleven, and would love to be able to get a Slurpee in town at 3 in the morning. But I don't want to put myself at risk or my children at risk to do it.
Okay, so is there anyone else from the board who has a question for Mr. Solomon? Okay. And Mr. Baker, do you have anything?
I was thinking of reserving my right to cross-examine him because he was kind of testifying as an expert, but
No, I just want to be clear, he's not. I mean, I made that, that was a stipulation that was made. He was not testifying as an expert in this matter. Okay.
Okay, so.
Any questions from the members of the public, Mr. Simon?
Yes, Mr. Pumper. You have to state your name, of course.
My name is Gerald Pumper, 348 South Avenue. I have a question for you, Randy. Do you understand why I feel personally insulted by the implication of your comment that there was some secret deliberation by the redevelopment agency of which I've been a member, and that you did not have an opportunity to read the agenda, to come to the meetings? There was more than one meeting. This was well known. There were members of the public there, and I wonder if you understand that.
I absolutely do. I really do. But I want to be perfectly clear. I said the exact opposite of that. I said that I think that everything that you did was totally well-intentioned, and the reason that people didn't get word of what had happened, didn't know, is just because the planning board has more traditional procedures where they have to notice people within 200 feet of a development and tell them that there's going to be a public hearing at a particular time and place, that it sort of sends a signal and to everyone that this is when it's your time to comment. And I think you did everything exactly the way that you were supposed to and the way that you were advised to. And I think that this will be a lesson because I think you can't deny the fact that there were lots of people that, when they did actually get wind of it, wanted to have comment. So I think it's incumbent on us in a democracy and wanting to do the best job we can of instituting democratic procedures to evolve our procedures to give people a better opportunity to have input in the future. And hopefully, it will, as my future colleagues will consider that.
Okay, so I don't want to go back and forth about noticing with redevelopment per se.
Well, I did not think that there was a conspiracy or that you guys were operating in secret or had any untoward intentions whatsoever.
You praise the planning board appropriately because they provide the legal notice that they need to people within 200 feet. The redevelopment agency also complied with the law and provided every notice that was legally required.
Gentlemen.
Specific, but that's not. I will not allow you to make the implication.
I don't.
Gentlemen, it's the situation. This is not about notice issues in terms of the interplay between the planning board and the redevelopment agency. So I think that the discussion should end at this point.
May I make one more conciliatory remark?
No, you can do that
Because you
privately.
made several, and I think that's for another place. So. I just want to ask you one final question before you step down, and that's just what is the number of people in Highland Park Future? What is the organization?
I think it's 6.
6 or 7 or 8. I previously provided a list
Right.
to the planning board.
And has that list changed in any way?
It has not.
So the original group that formed and hired you did not grow in any way? Okay.
We didn't try to grow.
Okay. Thank you.
One quick question, Randy. So you're staying on Highland Park Future as well as being on the redevelopment agency?
Well, Highland Park Future, it's not like it's an incorporated entity, and I have had a conversation with Mr. Liebling, who's the attorney for the redevelopment agency, about a potential conflict. And if there was a potential conflict to the point where Highland Park Future remained active and was bringing applications before the redevelopment agency, and I had to recuse myself all the time, then what's the point of being a commissioner? So at that point, I would not be part of Highland Park Future. But I think it's, yeah. So for right now, it doesn't matter.
I mean, it's outside the purview. It's outside the purview of this board. But I was just thinking.
You're right.
Well, I went through the implications of it with the attorney, and we were both in agreement that it would be fine.
Okay. Thank you,
Okay.
Ms.
Thank you all
Meyer.
very much.
Okay. So at this time, I am going to open up the meeting to the public for comment, but I want to start this public portion session with Mickey Landis, who is on the redevelopment agency. The board has requested, different questions have come up over time since this was specifically a redevelopment plan and came through the redevelopment agency.
Madam Chair, you might want to also indicate the length by which the board will continue to go. It's my understanding and maybe you want to talk to the board, but
Well,
my
yeah,
understanding
we
11
could-
o'clock.
We could take a poll. I would suggest 11, and we could also revisit it at that moment if we thought we could hear from anyone who wanted to speak from the public. By giving it a few more minutes, maybe we could visit that at that time. But at this point, are we comfortable going to 11? Yes? Okay, so I guess also keep that in mind, that we'd like to give as many people as possible an opportunity to have their comments heard. So, Mr. Landis?
Sir, do you swear the testimony that you're about to give will be the truth, so help you God?
Yes.
Would you state your name and address, please, for the record?
Mitchell Landis, more commonly known as Mickey, 204 Harrison Avenue, Highland Park.
Thank you, Mr. Landis.
I did not prepare a speech. Actually, I didn't know whether or not I would be speaking this evening. I did take notes throughout, and so I wanted to address a number of issues. Where you've asked people their background and qualifications, I would tell you that my schooling, both undergraduate and graduate, was in economics at New York University. I've been involved in professional commercial real estate development for over 40 years. I moved into Highland Park in 1956, 56 years ago. I have 4 children and a wife who live with me in Highland Park. We moved here specifically because it is a walking town, and much of the testimony that we've all heard tonight is I fully agree with as the exact reasons to be here. I think it's it's a very different town from when I first moved here, and I don't mind saying it. There weren't the horse stables that that Jim Nichols talked about, but not far from that. There was a sweet shop on every avenue corner when I was a child growing up here. Uses have changed, the environment has changed, but more importantly, I wanted to talk a little bit about how we came to a decision to approve this, because I think that that's really at the heart of what people have been questioning, and many of the questions are very fair and very appropriate. In fact, many of the positions taken tonight I agree with, and many I disagree with, and I'll try to go through some from the notes that I took. But I want to make it clear that the approval was not done in a vacuum. We had over 2 years of meetings with the applicants to come up with a plan for a property which we have never had an applicant before or after for that site. One of the things I would disagree with a few of the people who testified is that there is this pickup in development that is forecast. I've also read forecasts, and I personally believe that we are in for a very long haul with a lack of development activity in the state of New Jersey for a vast number of reasons that I don't want to get into. But clearly there's much evidence that New Jersey is going to suffer for redevelopment for many years. And I'm not saying that we should pick and accept the first applicant that comes, but as I said, this was not done in a vacuum. When this applicant first approached us over 3 years ago, the idea was to reuse the existing gas station building. It was to reuse the 30-foot pylon sign. It was to put up interior illuminated plastic signs. It was to keep all of the curb cuts. There were significant modifications that we requested to this plan in order to even consider it. And the applicant was cooperative in all of our requests. And we set up a subcommittee which met with the applicant on 2 occasions, I believe. Members of this planning board were in that subcommittee. We did not want to take on any application in a vacuum because we want to work with the planning board. And so Heather and I believe Paul, if I'm correct, were part of a subcommittee which met on at least 2 occasions. The approval that we ended up with was unanimous. I have to tell you, it's not as if it was controversial, but I want to let you know where it was changed from where it started. We felt that it was important to get rid of the building that was there. We took the initiative to ask council to take the gas station out of the plan and make it no longer eligible for a gas station, which you heard happened in 2010. That wasn't for the sake of bringing in a 7-Eleven. That was for the sake of getting rid of a gas station. We are all residents of Highland Park on the redevelopment agency, and we seek the same things that everyone else here seeks, a safe walking community. And so our intent was to get rid of the gas station. So, for example, while I would agree with Mr. Constantine's testimony that this is a very important corner, I would fully disagree with him that we have a fairly intact Main Street on the blocks to the south. On the blocks to the south, what we have is actually a bunch of auto repair shops on the west side, which have almost continuous curb cuts, and I would call it anything but what we want, and in fact, it's a major target of the redevelopment agency to get rid of these auto repair shops from the heart of our business district. It's also one of our objectives to get rid of all curb cuts, and we do intend to minimize curb cuts wherever possible. I would point back to different plans that have been approved, not by the redevelopment agency, but by this planning board and others that do allow curb cuts, that did not take away curb cuts from such places as Dunkin' Donuts. They were kept in place for businesses to be viable. And so I think to a certain extent what we're hearing makes sense to me. We all want less curb cuts, but it's a little inconsistent. I've had this conversation with many people who've said they oppose this because there's a curb cut. What we viewed was that we were reducing existing curb cuts. We felt it was significant to cut the curb cuts on Route 27 by half, which is approximately what the approved plan does. We felt it was significant to move the building from the existing gas station location to the south side of the site. By doing so, which is actually not that different from Jim Nichols' Plan B, not the one shown here, the other where there is a lot on the corner and the building is moved further south, we felt that it offered exposure to both the 2nd Avenue Reformed Church, which we viewed as one of the jewels of town, as well as the strip mall behind it. And for clarification purposes, where BB Big is located is a strip mall, where several people have erroneously called the 7-Eleven building a strip mall. I'm not sure what they're talking about, but that's not a proper term for a 2-story mixed-use building. But where BB Big is a strip mall, and we felt that it would increase exposure by moving the building back. So again, what I'm trying to show is that the intent of what we were doing in modifying the original application was to fit Highland Park's needs and to improve the applicant's plan. In addition, the applicant wanted, and at the time was permitted to use the 30-foot pylon sign that the gas station had been using. Remember, we saw it, we went to council and said, let's get rid of the gas station use. Otherwise, Sunoco could sell to another gas station, and they have the right to locate there because it was exempted from the redevelopment plan. We didn't want it to be another gas station, and so we had that modified. We had the agreement of 7-Eleven even before that to get rid of the 30-foot pylon sign, and in its place put a monument sign. I've heard a lot of people say today that they think the monument sign is hideous. All I can tell you is it started with a 30-foot pylon sign that was interior illuminated plastic. It went to a ground sign that was interior illuminated plastic. We would not accept that. We reduced the size of the sign, and we made it exterior illuminated by spotlight rather than, again, interior illuminated. I mean, we made significant changes in this plan. We spent over 2 years doing this. These were in open public meetings, fully noticed. I don't disagree with what Randy said. If there were a requirement of a redevelopment agency to notice people within some footage of an application within their neighborhood, I think we would have had more people there. There is no such requirement by statute, nor had we ever been asked to do it. I think we can talk about it. We'll check with council and see if it's appropriate. It may or may not be, because I think it's a good idea, frankly. So we would get more feedback. But in over 2 years of meetings, I think I can safely say we never had one member of the public come out and speak against the application. What we had was a group of commissioners who were dedicated to modifying the application to try to suit Highland Park. We had an applicant that met all of our requests every step of the way. Could it have gone further? I've seen some plans today that look better. I don't mind saying that, but they're theoretical. And it doesn't mean that there is a business that's willing to invest in that money. And at the end of the day, we have to remember that what we're dealing with here is the redevelopment of a site by someone who's investing money. As I said, I'm in commercial real estate. I've been in it for 40 years. I know it well enough to understand that if there isn't a viable business plan, there's no plan. So theoretical plans may or may not work. The question is the applicant willing to do that? I can't answer that for them. We found that they met all of the requests that we made to modify the plan to improve to Highland Park. We felt that we were getting a Highland Park model as opposed to the highway model. And that goes to all the things I talked about. No interior illuminated plastic signs, no pylon signs, cutting the curb cut, et cetera, et cetera. Did they go as far as we've seen tonight that perhaps they could go? Obviously not. Are they willing to? I can't speak to that. That would be their call. I can tell you that in addition to having a group of volunteer commissioners who are not just dedicated to trying to improve Highland Park's business district, they're very knowledgeable people. They include people who are, one is a doctor who's a planner at the Blaustein School. And when I say this was unanimously approved, we're talking about a group of people who are professionals, who understand what it was, who felt that this was appropriate for Highland Park. I'm not saying this is the best thing, but I'm saying that our job is not to determine who the user is. Our job is not to determine what the absolute best use could be. It's to determine if an applicant that comes before us is appropriate for redevelopment. We viewed all of the criteria. We actually have done outreach to try to bring other users into town at that site or other sites. I personally approached, for example, Trader Joe's on 3 occasions. I spoke with them twice, and they told me the same thing, that many other businesses that we thought we would like in Highland Park, that I was told by many citizens we'd like in Highland Park, and we wanted to focus on for redevelopment, I've been given the same answer repeatedly. Highland Park does not meet the demographic requirements for them to locate. We couldn't beg them to come here. Trader Joe's, that is, and many others. The demographic requirements are not easy here. Yes, we know we're close to Rutgers. We know we're close to a lot of other things. It doesn't mean that it's a population that spends money. It doesn't mean that it's a dense enough population, but it is what we are here for. It's a small walking town. We love that, and we want to keep it active. We want to keep it vibrant, and we did feel unanimously that a closed gas station is about the worst thing we could have in town. We can't speak to a specific business as to whether it's the best business we want in town, because we don't feel that's our job. We feel that they may or may not make it. I've heard people talk tonight about Park Deli and other national chains, and I would tell you that Park Deli basically has outperformed national chains right across the street from them, perhaps been involved in putting them out of business. I've heard 7-Eleven's going to put Park Deli out of business. I'll tell you, my view is because Park Deli is well operated, as is Dunkin' Donuts, I think they put out of business Quiznos, and before that Subway, and I think the current Subways. It's not that because you're a national chain that you have the money to spend that you make it. It's how do you operate your business. Again, I grew up here over 50 years ago. I'm in my 60s now. And I've been personal friends of the Safe family my entire life. I'm still friends with the Safe family. Unfortunately, I don't go to their drugstore. Why not? I mean, shouldn't we support the local family-owned small drugstore? But the answer is Rite Aid has longer operating hours. They have larger selection. So if they have what I need for my family's health and safety, I'm going to go to the one that offers a better solution. Business seeks its own level, and it is successful based on how it's run. I fully believe that Jenny's store is successful because they do a great job of providing product that the public here wants. If you don't, you don't succeed. If a business comes in here, if it's 7-Eleven, and people here don't want to patronize it, it will fail. There will still be a building there. We'll get somebody else there, just as we did in the redevelopment directly across the street. The business that Arit Mayo brought there didn't make it. It failed. There will be another business there. Whatever it is, I can tell you it's a hell of a lot better than the 1 hour Martinizing that we had there for about 30 years. It would be nice to have the old fire station that preceded that, but we can't. Businesses make it based on public response. I don't think we should be sitting here judging BB Big or 7-Eleven. I don't think that's our responsibility. I think what we have to look at is how can we get what we want for our community out of a company that's willing to invest in our community. It is not easy to find companies that will accept the demographic limitations of Highland Park. And when we find them, what we should do is, rather than turn them away, is try to work with them and get them to do what we want. The redevelopment agency felt that we achieved that. If the planning board feels that it has to go further, we'll applaud that, so long as you can get it. If it means you lose it, then it's hard to applaud it. I want to talk about I also heard a few people talk tonight about the linkage of parking and the alley approach to parking behind buildings. This is...
Maybe if you could do this in a summary fashion.
This is a new item.
I understand that.
I'd be happy to come back another time and speak, because I realize time is limited.
I know, Ms. Thomas, the board specifically requested that they speak,
I'll withdraw
so
the
this
comment.
is important.
In terms of the linkage of parking, the alley approach that several people testified to, we completely support that. And in fact, the redevelopment agency has attempted on several occasions to develop a parking somewhat to Somerville, if those of you are familiar, where they've had successful redevelopment, where all the businesses are on the main street, all the parking lots are behind, and they all link, even where it's a bizarre linkage and you have to go in L formations, they do it. And it works, and they're getting more and more business, including many competing businesses. They're getting many, many restaurants. I don't mind competing businesses. I don't mind if we get more food shops, just as I'd be thrilled if we got more restaurants. But the linkage hasn't always worked. In fact, the linkage from the Rite Aid lot to 3rd Avenue was turned down at the planning board after we had the agreement with the applicant to do that. So it hasn't always been implemented. I'd like to see that, and if that really is an item that the planning board is interested in, we would applaud that, and we would welcome whatever this board could do to get back to that theory that we have supported and that we've been pushing. We do agree that downtown redevelopment in a walking town should have the parking behind the buildings, which several people testified to today. We heard about design guidelines which would preserve historic and visual appeal, normal standards, reduce driveways, not have an adverse effect on streetscape, and not have an adverse impact on the neighborhood. We agree with all of those elements of the plan. That's precisely what we hope to see. And honestly, I don't see how changing the current closed gas station, and again, this is not take whatever you can get because what you have is so horrible, but rather we don't see how it violates any of that. This is a very important corner. It's where Route 27 has a slight turn, so the visibility is significant, and it will have quite an impact on the look. The alternate plans that we saw, as I said, do not bother me. I think that some of them make some sense that Jim showed, but again, they have to make sense to an applicant who's willing to invest in the property. And with that, let me end in case there are people who have some questions regarding redevelopment and how we approved it.
So does the board have questions for?
I do. I just had a couple questions. One is an easy one, I think. When you said earlier that, I guess, the placement of the building would increase exposure for the other, do you mean visibility from Raritan? What did you mean by
Yes, visibility from Route 27. It would increase the exposure to both the 2nd Avenue Reformed Church and the strip mall where
people
BB
could
Big is.
see it as
Right
they-
now, you can't see them
Right.
because it's blocked by a garage for Sunoco. That was where the applicant first wanted to locate, in the existing garage. We wanted to open the exposure to those two facilities, both the strip mall and the church. That was one of the purposes of moving it. So that's why I didn't really understand why one of the views shown, the one here, pulls it out to the corner. I'm not sure if that's better or not. we felt that moving it to the south would open more exposure to those other two views.
From an aesthetic viewpoint. In other words, aesthetically, it would expose the church, which is an architectural feature.
Correct.
And you're saying from a business perspective for the strip mall behind it?
Correct.
And related, kind of similar, I was just wondering if it was a consideration of the redevelopment agency, was the concern that some other business would come in and seek to reuse that building, that because I guess I wasn't aware of the fact if that building was reusable or not, and it sounds like it's potentially could be. I mean, was that
Until we went to council in 2010, which I said is after this applicant came to us, it was excluded from the redevelopment plan, which meant that Sunoco had the right to sell it or reuse it as a gas station or sell it to another gas station user. And that's what we wanted to eliminate. And that's exactly what we effected through council.
Well, I was meaning, it sounded like what you said was 7-Eleven initially said, well, we can reuse that garage.
We didn't.
Right, that is
business.
what you
Is that
said.
what you were saying, or maybe I misunderstood?
That they were just going to move into the
accept that.
existing structure.
That's
Yeah,
correct.
I'm just saying, I wasn't sure if, being that it was a garage for a million years, if it even was reusable for something like that.
It's not that they had a right to.
Okay.
No, that wasn't a right of theirs.
Okay.
But there was a right for somebody to reopen a gas station there, with all of the existing curb cuts, with the 30-foot pylon sign. All of those were existing rights that we eliminated in 2010.
And then just one more point, I don't know if it's for Mr. Landis or for our attorney, and this is more about the protocols for approvals for the agency versus the planning board. When we're looking at variances, I understand we have to look at those proofs and weigh the positive and negative criteria. And I'm not quite sure, I'm not familiar with the redevelopment agency. They're not weighted down by those proofs in the same way? I mean, I know they must have considered them, but.
Well, I'm not going to get into what they may have done or may not have done. But the answer, I think, to your question that's relevant to this process is that you have the redevelopment plan, okay? The redevelopment plan is, in fact, the ordinance that applies to this site. To the extent that it encompasses designs and all those other things. To the extent that there are things that it does not cover, then the zoning ordinance applies. In both cases, if there's a deviation, they have to be dealt with either by way in a standard that the municipal land use law requires, which means that they either have to go through a variance process, even though it's in the redevelopment plan. They have to go through a variance process or a design waiver standard. So your review is the same as if this was all part of the municipal land use law and the zoning. The only difference is that you're going to be looking at the redevelopment plan as part of your consideration, and where there's deviations, the same standards that you always apply will apply here.
I think I understood that, I guess, and I think you answered my question, but what I was really trying to get at was just a better understanding of the deliberations of the different agencies, and it sounds like they're not by law required to look at the same things.
I'm not going to get into what their jurisdiction is, because quite frankly, that's really not my job to be telling them what to do, and I am a little hesitant to do that. So whatever they did, they did. They had counsel, their counsel advised them, and that's where I think I should leave it. Whether or not, I can advise you as to what your standards are. Okay?
Fair enough. Thank you.
And Madam Chairperson, we also would be happy to bring counsel to one of these hearings to explain any element of this that might be questioned. A shortened version of what Mr. Thomas explained is that the redevelopment plan is an overlay of the zoning plan. I think you would agree.
That's a reasonable way to approach it.
It's just a shortened version of it. And all of the people who are appointed commissioners are required to attend courses to learn redevelopment and understand the process. 2 courses given by Rutgers, and all the commissioners who have been sitting at least a certain amount of time have fulfilled that requirement.
Yeah, I'm familiar. I think I think I'm asking a different question, but I don't really care about getting the answer. It's all right, I will let it go.
So I think you made a statement that said all our requests were either heard or they had heard our requests, and you talked about being able to move the applicant from wanting to pretty much take over the existing building to the application that's before us. Would you say that you had asked for more and there was a lot of pushback, and this is as far as you got, or do you feel that that basically this was what you asked for and they met you at that, you know, whether it be size of the parking lot, size of the building, the two-story, whatever the different elements were
I would
of
say that
redevelopment
everything we asked for, with the exception of could we eliminate the curb cuts fully on Route 27, everything was agreeable. To their business plan, that was not agreeable.
So that was something you brought to them saying, ideally, we really just don't want any curb cuts
Right.
here, right?
Right. And as I said, at the end, it was cut, I believe, about in half, the amount of the curb cut there.
From what they were initially proposing?
From what's currently there.
Well, from what's currently there. Okay.
Alan? Oh, I'm sorry.
Heather?
I think you mentioned the fact that it's the 7-Eleven, that seems to be a point of contention. And I just want to clarify, from my viewpoint, and I think from most of what I heard today, is that I don't think the objections, at least my objections or my concerns, are not about it being a 7-Eleven, but that we get the site right, because the 7-Eleven, you're right, could go away in 10 years, but the building is going to be there, and the site that we develop will be there for 50 to 100 years. So I think that's the bigger concern, is not that it's a 7-Eleven, but that we get the development of the site right. And the 7-Eleven, you know, certainly everybody has a right to have a business here. And then I also wanted to clarify.
Is that a question or is that a question or a comment?
That was a comment. Sorry.
And I would tell you that I agree with what you said in terms of what I heard tonight. When I was saying people objected to 7-Eleven, I didn't hear any objections tonight at all. But much of the prior discussion that I've heard for the last few months has, and not just discussion here, but unfortunately people have put things in writing, as I'm sure you've read some, and much of it has to do with 7-Eleven, how they treat other businesses, how they treat their employees, and too much of the discussion focused on that. And I know that this board.
Actually, I just want to interrupt, because we have not actually heard, like in any of our prior meetings, that
okay,
type
good,
of
because I know
comment.
that this board and the redevelopment agency both were only concerned with the what the application was. And tonight, that's all I heard. I heard nothing about any issue with the particular business, so I agree with that.
Then secondly, Paul and I were on that liaison committee from the planning board to the redevelopment board. And my question is, I guess, I did put together a memo that outlined almost all the questions that I am bringing forward now, and a lot of the concerns and questions that we hear. And I believe that was given to the redevelopment board. And I just want to make sure that you guys did receive that documentation from Paul and I, from the liaison committee of the planning board to the redevelopment board.
What I can say is that we asked if the subcommittee needed additional meetings, and we were not told that any were needed. So what you're saying is perhaps there should have been further meetings, and I wasn't aware of that, I have to tell you.
And then my other question is similar to Terry, sorry. For some reason I'm thinking Jackie. And it's a question about procedure, and maybe this is not the time to clarify it, but it may be helpful for the public also. The redevelopment group approves a basic site plan and redevelopment of a site. We are really tasked to make sure that that site is functional and fits within the constraints of the documentation that the town is held to. And we work with the applicant to get it right. Is that right?
Generally, I would say yes. It's a little bit more technical than that, but generally I would agree. If it turns out what you are dealing with, just like you deal with any other site plan, you're dealing with the ordinance. You're not in a position to say the ordinance should be changed. All you're in a position to do is to listen to the application, and if there's a deviation from the ordinance, then the applicant must establish the parameters for how that deviation is justified. So that's the variance process, and you do that all the time. The same process that you're concerned about is what happens in this application. It's just that you have an overlay, as has been suggested, that in addition to the zoning ordinance, you have to look at what the standards are for the redevelopment plan. So it's no different.
Okay, does anyone from the board?
So, over the course of time, when the redevelopment agency was dealing with this property, I think you said that this was the only applicant that came forward, or you had serious discussions with. Is that?
No, it's the only applicant that in over 6 years of the redevelopment agency that it's been around, that anyone has shown any interest in that specific site to the redevelopment agency.
And were there discussions, I guess, with other developers over that time in terms of the block as a whole, or only?
No.
As opposed to just this site?
No. We spoke with a redeveloper. We approved a redevelopment adjacent to it with the Chen family. They did not get the financing that enabled them to proceed. We spoke with 2 prospective redevelopers for the old senior center site between 2nd and 3rd, and we tried to convince either one of them to go after this site, and neither was interested.
Get a sense of why we didn't get much more interest, or, you know?
Couldn't tell you. I wish I knew.
Thank you.
I have,
Oh, I'm sorry,
Yeah.
Mr. Linares.
Hi, Mickey.
Well, I attended the meetings.
If I'd known you were in the room when I said all those things about you, I would have mentioned what a good fisherman you are. But, you know, I often wondered that if the tenant were Trader Joe's, we would have as much public pushback as we do. But my question is, can you speak to the antecedents and the circumstances around the second story? The applicant has made testimony on several occasions that this is a unique building in and of itself to 7-Eleven. And I was just wondering of the history of that.
I can't speak as to the uniqueness for 7-Eleven, but I can tell you that one of the things we look for in the redevelopment plan is mixed use. Is one of the things that bothered me about some of the presentations tonight of alternative theories. Those are not true mixed-use buildings. You have, as your council pointed out, you have one use in one building, another use in another. The redevelopment plan is looking for mixed use. We're looking for retail on the ground floor. We're looking for office and or residential above. We're looking to go anywhere from 2 to 4 stories, and there's a number of criteria that we use for setbacks and height in the redevelopment plan for that. But the purpose, again, of the mixed use is to enhance the walking nature of the town. The belief is that if you have more people who live near where they can buy, where they could work, you encourage walking, you reduce vehicular traffic, and these are all precepts that I believe everyone in this room would approve of. You know, we all want to reduce vehicular traffic. We all want to increase pedestrian traffic. And again, you know, it strikes me as a little bit unusual or odd to me that nobody has said a word in the past few years about shutting down the driveway at Petmar, which we closed in redevelopment, and that's a mid-block conflict, which is a true safety hazard for, as someone pointed out in your group, for people, for children, for elderly people, for bicyclists. The mid-block hazard is the most dangerous. And the Petmar driveway was supposed to be shut by a redevelopment plan. Nobody has come forward talking about that, but a lot of people are talking about a corner conflict, which, as somebody else fairly pointed out, is not as serious because it's much more visible when you're approaching it. It's that mid-block conflict of a driveway that's terrible. Why aren't people clamoring to get rid of these things? We should. We would support that. We in fact asked for it.
Okay.
Okay?
Mickey, is it fair to characterize the second story as a concession?
They probably conceded that to us because we said we needed something. So I guess they'll have people living upstairs. They'll have, I don't know if it's residents, employees. It's still a mixed use because, again, if you have retail on first floor, office and or residential above, you're promoting mixed use, which promotes more pedestrian traffic, less vehicular traffic, more density to your downtown, which is all, these are all precepts of redevelopment that I'm sure the planning board would agree with.
Thank
you. Okay. Thank you, Mr. Landis. I want to remind everyone that we are still in our public portion of the meeting. We did say that we would...
There may be some questions of Mr. Landis by the public.
Oh, okay. Yeah. Well, I... We will. I just want to review it is 11 o'clock. So I think, right, because we still have to, are people willing to go on a little further and revisit?
Don't ask me that.
Why don't you make a suggestion? Yes. Yeah, okay. So why don't we say 15 more minutes? Is that reasonable? Okay. So yes, so we'll just go 15 more minutes. It would be great if, yes, if anyone from the public has, I guess, a question for, is that what we're doing?
Yes.
For Mr. Landis?
Yeah, I think
and
that'd
then,
be fair, so he doesn't
yeah,
have to come
yes. Okay.
Sure. I just have a few brief questions for Mr. Landis. And I think it may...
Mr. Landis, if you'd be kind enough to come back so we can pick you up on the mic. No, you're still under oath. Great. You got to hold it for a little bit. Actually, Alex knows exactly how to do that now.
My first question, Mr. Landis, I think may actually clarify the question that Mr. O'Leary was trying to ask before. You stated a few times that the redevelopment agency approved of the application or, gave approval of the proposed project. And I was just looking for a clarification as to what you meant by that the redevelopment agency had some sort of approval over the project that was proposed to the redevelopment agency.
I'm really not sure that I understand your question at all. We had a formal vote to approve it, and it was unanimously approved, and it's of record. I'm not sure what the question is.
Okay. I guess my question was, I was seeking a clarification as to what approval the redevelopment agency gave to the project.
I can clarify that. There's a jurisdictional distinction between a redevelopment agency and a planning board. So therefore, the redevelopment agency, according to the normal course of events, which happened here, is that they end up obviously developing the redevelopment plan, and then whenever there's a project, they have an initial review of that, and then they jurisdictionally have the right to either approve that plan and or reject it, or presumably modify it, I guess, which sounds like that's what was done. Then the plan must come to the planning board for an additional approval. So there are approval processes in the redevelopment plan, or the redevelopment agency.
I think that you mentioned that during the discussions with the developer, that the curb cut was what we'll call a deal breaker. That is, if they weren't able to get the curb cut, that this would not be a viable project for them. Is that correct?
Yes.
Okay. And also the same goes for the monument sign. Is that correct?
We didn't make that a deal breaker on our side either. We had no problem with the monument sign.
Okay. And I guess my question then is that, within the authority of the redevelopment agency, was there any consideration given by the agency to amend the redevelopment plan to remove the prohibition against the monument sign and also the prohibition against the curb cut on Raritan Avenue?
There was discussion of these elements, but not a discussion to amend the plan.
And I guess in terms of the redevelopment agency's endorsement of this project by its unanimous approval, knowing that is going to have to come then before the planning board with two fairly major controversial variances, is there a reason why the redevelopment agency wouldn't consider amending the redevelopment plan and thereby eliminating the need for this applicant to come before the planning board?
Every applicant that the redevelopment agency hears goes through the planning board, is my understanding. And so the extent of the variances needed was not something that we discussed. That's something for the planning board to determine. We felt that the changes that had been modifications that were agreed upon were agreeable to our agency, and we felt it could come to the planning board, and it might be agreeable to this agency.
Mr. Landis, have you been present during the planning board hearings that we've had on this application?
No, this is the first planning board hearing I've been to regarding. No, this is the first planning board hearing I believe I've been to in Highland Park. I've been to many for my own business, but in Highland Park, I don't believe in all my years I've attended a planning board meeting.
And have you had an opportunity to listen to or to review any of the written transcripts that come out of these hearings?
No, I haven't.
And then my last last question deals with the mixed use that's being proposed by the applicant. You suggested that if the second floor is being used for office space or for some residential component, that would meet the mixed use definition in your experience in real estate or redevelopment, retail on the bottom and either office space or residential on top.
Correct. That's correct.
And are you aware of the limited scope of the proposed use of the second floor by this applicant in his present application?
I'm not sure what you mean.
I guess maybe the better question to ask is, what is your understanding as to what is being proposed for the second floor by this application before the board?
We were told it would be used for residential space or office, which met our criteria.
Yeah, and I guess I'd ask whether or not you were aware of the fact that there's only an interior access within the kitchen of the 7-Eleven to go upstairs to the second floor. And there's also no, as I understand, no separate plumbing or water source of the upstairs. And I would imagine that would eliminate any sort of residential use.
The view of the applicant in terms of whether it meets code for plumbing, for stairwells, is not a purview of the redevelopment agency. That's handled by the code officials, and they would not be permitted to use it if they don't meet code. So, I mean, that's not something we look at. To be honest, the redevelopment agency does not go into that detail of an application.
The testimony that's been provided by the applicant, and I had asked whether or not you had attended the hearings or not, and I understand now why you may not be aware of it, but the testimony that's been provided by the applicant as to the proposed use of that second floor, frankly, is really just for their own internal office use. It's not going to necessarily engender the benefits that you discussed that mixed-use development would attract. Certainly on a site like this, you suggested a 3- or 4-story mixed-use redevelopment would attract much more foot traffic, much more interest in that particular property. This 7-Eleven store, the second floor, will only be used for 7-Eleven's purposes. And I guess my question really then is that really mixed use in your mind, based on what your description was of what mixed use redevelopment should be?
It would not be optimal mixed use. It would still probably qualify as mixed use. It wouldn't be my first preference now.
Thank you.
Okay, does anyone else have any questions? Okay. Please state your name and address for the record.
Hi, Rob Rosener, 22 Harrison Avenue. Is this on?
We think.
I don't know, your finger's covering the little red dot. Yeah.
I was curious how extensively the redevelopment agency marketed, if at all, and if they do market the site, and if you know if I guess the owner has it on the market, obviously, how many nibbles they may have gotten independent from 7-Eleven.
That's a good question. Sunoco marketed the site for some period of time. I don't know how they marketed it, but I understand that they were trying to sell it for some time. They, in fact, spoke at one point to us about a prospective new gas station user. But that party never appeared to us. We never met them, so we don't know if that was real or not. In terms of how we market, it's a great question. There are some towns that have been more successful at redevelopment than we have been. There are times that I'm embarrassed at how little we've accomplished in the years that I've been on the redevelopment agency. Even though they're tough times, what you have to remember is that we have no paid members. It's an all-volunteer citizen group. The Woodbridge Redevelopment Agency has 3 full-time employees. They have a budget of over $500,000 a year for marketing. And so I receive regularly full-color mailers from Woodbridge about why I should put a business there. There are ways that you can be more successful with redevelopment. I don't think that's what Highland Park wants. I happen to agree with Highland Park's approach. We don't need to spend millions of dollars of taxpayer money to try to find people interested in putting up a business here. What we can do is work, as your board does and ours, with volunteer citizens who hope to get redevelopers in. But we have, as I say, no budget, no paid staff, so we don't do any serious marketing, is the answer.
Okay. would there be no budget even to like perhaps retain a commercial real estate broker on behalf of the agency then, just to kind of go out and look around as opposed to maybe making flyers and things that might cost more money?
Working on a daily basis for the last 40 years with commercial real estate brokers, I could tell you that that would significantly benefit the broker, but not the town.
Okay. Is there anyone else that has a question for Mr. Landis? Yes? Again, you have to state your name, please.
I'm Shelley Saul. I live at 437 Denison in Highland Park. And I don't know. Yeah, sure.
He sat in the right seat.
That's his new part-time job.
Yeah. All right, I'll just project.
You can pass this mic back and forth.
Yeah, no, it's okay. I can project.
Do we need
I'm
it for
good.
the recording?
No.
Okay, hello. All right, Shelley Saul, 437 Denison. Actually, I'm taking a risk here because it seems that we're running out of time. So I'm hoping this deals with the redevelopment person. Has anybody from the planning board, redevelopment, has a proposed builder come up with any hypothetical billables or assessed values who can look at not only at the square footage, but at the cost of improvement and value when assessing the property? Then can that person relay the information to the public? I personally deal much better with numbers and to understand what the benefits are of building a new building and for the projected purposes of it, versus keeping the building the way it is, in the condition it is, and living with it as a town without any kind of new development, whether using the existing building or not. My greatest concern is we're losing money as we're talking. It's been how many years since we first heard about this development, and that it, you know, we have to take risks, and our times of poor economic circumstances, maybe at this point we need to go ahead with a building like this, and it would help me to know financially, for the benefit of the borough and the property tax payers right now, if going forward with a more commercial building is worth our while at this point in time. And then with all the other places we have open, not being occupied, those will stay that way. But can we bring somebody in? Has anybody done the numbers?
If you feel comfortable speaking to that, you can. In general, it's not something that the planning board considers as part of the criteria.
Okay.
But
maybe redevelopment does. I don't know.
We do, because it's one of the goals of the redevelopment agency is to enhance the tax base and to help the residential taxes. The answer is we did not do a study to determine exactly what the amount of taxes that would be generated by this specific building would be. But I can refute a statement that was made this evening that there would be no difference in taxes because there's already a building there. A vacant building does not pay full tax. And so to say it doesn't matter if there's a new building or a vacant gas station is not correct. It would pay more tax. Study, I can't give you a number. I can tell you there would be more taxes paid by a viable business operating building than a vacant building. That I can assure you of.
Can anybody do some hypothetical numbers so that we can really think about this concretely and see the black and white? I mean, we're looking at, if numbers are what we're looking at, aside from the aesthetics and the beauty and the community, we're also looking at numbers. We're hurting.
Well, as I said, it would be paying significantly more taxes than a vacant building.
Okay. And again, that's just not an issue that the planning board is yes. Okay.
For redevelopment, that's an issue.
Okay. So does anyone else have a question for Mr. Landis then at this time? Okay. Seeing none. All right. He got in right. Well, we're trying to get to that part, but there's a little, we have to go through all of our steps to get there. So, Terry, we got 2 more minutes on the clock. Are you?
I'm okay. I got a text that things are.
Things are okay at home. Okay. Okay, so again, this is a time for public comment. It looks like we do have a lot of people here, so I am going to request, since we're actually gone past 2 of our deadlines now, that you keep your comments, you know, as brief as you can, and still state what you feel you need to say about this application. Again, when you come to the mic, please state your name and address for the record. Yes?
Sir, do you swear the testimony that you're about to give will be the truth, so help you God?
Yes.
Would you state your name and address, please, for the record?
My name is Gerald Pomper, 348 South 3rd Avenue. If I may, and it may save you time, I have a written statement that if you take things for the record, I could give you and just summarize now.
Well, if you'd like to summarize, I'm a little reluctant to take written statements, but why don't you summarize what you have to say?
All right. First of all, I appreciate the care you've been giving this issue. I've been attending your meetings for 6 months, and I'm very impressed with your expertise and your dedication. I'm speaking as somebody with the experience of being a member of the redevelopment agency for a good many years. I'm not speaking for the agency. Our chair has done that and done it very well. But I am not pretending that I was not influenced by that experience. I just want to make 4 principal points, and I will try to summarize them. First of all, I do think this project is an asset to the community, and that the intent of the redevelopment plan is not simply to make Highland Park more of a walking community, but to improve its economic base. And this will be the first combined office and retail building, I think, in decades. It will bring a new building to the most blighted block in the downtown area, and to a corner which has now become twice vacant on 2 corners with the closing of the stores and the firehouse. It's a dangerous place. The fence, you may have noticed, was completely blown down by Hurricane Sandy. That's a danger to people who are passing by, obviously, and it's incredibly ugly. Now, we can talk about other alternatives, but I had the feeling I was in an architecture school contest earlier. We were looking at one real alternative and one theoretical alternative. And I think that theories are fine, and I'm an academic, but I think the planning board has to deal with real proposals rather than things that would be nice to have. If you look at this proposal, I think you have to be impressed by the way in which a developer has continually made changes to make this fit better with the design and the traditions and the character of Highland Park. Mickey has talked about a number of these. I'll mention there are 10 here that I can list. One of them is the question of access and curb cuts. When we had the 4-person subcommittee of Heather and Paul and Clint Andrews and myself, one of our concerns was curb cuts, and we were particularly concerned about the dangers to traffic of people making left turns into this site. The developer came up with the proposal to confine it so that only right turns could be made, and there would be no cross the avenue traffic. And at that point, it's my remembrance, Heather, I may be wrong, that all 4 of us said, yes, this is a plan we can go forward with. That's one of the major changes that they made. But you're familiar, you've been here 6 months, with all the changes in the design, the lighting, the signage, and so on. The changes in the delivery trucks, the schedule for that, and the turning radii, and so on, and the creation of an outdoor landscaped area. So I think there's been a great deal of improvement here. The real question for you is, I think, not the theoretical alternatives and, could an architect like Mr. Nichols come up with a better plan, but the real question is the plan that's before you. This plan is a permitted use on this site. There are only 2 issues remaining, vital issues, and they both involve the economic viability of this project. there has been testimony that something like 65% of their business will come from automobiles, and particularly on Raritan Avenue. This business cannot survive without that curb cut. And you may come to the decision, well, you don't want the business, and so, okay. But you should face that reality. The second reality is they need to have some means of being identified from the street, and that's where the monument sign, which is a huge improvement over the existing pylon, is important. And that pylon will stay there if this area remains vacant over all this time until it falls down and kills somebody. So I think you have to realize that. Final point I want to make is the opposition to this project. And this opposition is conscientious and as concerned with the welfare of Highland Park as anybody else in this room. So I don't question their motives, and I don't want to engage in an argument. But I think there are two kinds of objections that are really irrelevant to your consideration, but you have to be the judge of that. The first question is chain stores. There's an ideological opposition that some people have to chain stores and national businesses, and even in some cases to automobiles themselves. But we have chain stores in Highland Park. They're permitted.
I'm going to ask you to start.
So the other, 30 seconds?
Sure.
Okay. The other objection
20.
is that
20.
this business may hurt other businesses. I don't know about that, but this is a free market system, and I don't think either the redevelopment agency or you are in a position to provide protection for some businesses over others. I think you have to judge this site and this plan. And thank you for your
Okay, great. Thank you. Is there anyone else at this time wishing? I'm going to call on you with the white shirt because you had actually maybe beat Mr. Pomper to it last time, and he got to the mic first.
Sir, do you swear the testimony that you're about to give will be the truth, so help you God?
I do.
Would you state your name and address, please?
My name is Rob Scott. I live on 25 South 2nd Avenue. I'm here as a member of the public and as a parent of 3 children, and I have just 2 comments to make. I want to take as much time as I need to because I think what we can all agree to is everyone here really wants a chance to talk. I've been waiting a long time to talk. I came to a council meeting, I wrote a letter, I was told written comment couldn't be taken. It's very hard to make it to this meeting. My kids are passed out right now in front of a movie at a friend's house. If I had to come again, I was going to bring them. So I think everybody really wants to talk, and I think part of the reason people want to talk is because I found out about this, even though I'm a neighbor, I'm a renter, I didn't get the letter, but my neighbors got the letter. And letter found out about the proposed project and started to think about it. Now, I don't want to say that there was any kind of conspiracy or anything like that, and I think Mr. Solomon's comments were very kind and conciliatory. But the fact of the matter is, from my perspective, from where I sit, I didn't know about it. I didn't have a chance to comment when it was before the redevelopment agency. I didn't have a chance to say anything about it. I didn't know about it, and there really wasn't a way for me to know about it. And here we are at this meeting, and it's slightly ironic because public comment began at 10:22, and the first public comment was from a member of the redevelopment board who went on for 20 minutes.
Continue.
No, when public comment began,
we're listening to you now,
right,
so let's not have anybody from here.
Right. 20 minutes. And then the second piece of public comment was from somebody else on the redevelopment board. Well, I'm here as a member of the public, okay? And what I say to you, as all the members on the planning board, is that I want you not only to consider the needs of the 7-Eleven business and their business plan and whether they're going to make money off of traffic coming in off of the street, that is not what I think your primary concern should be. Your primary concern should be the needs of this community. And as a parent in this community, my primary and number one concern in this community is that my children don't die when they get hit by a car. And that's really what the curb cuts are about. It's not about aesthetics. It's not about this nice, that nice. It's not about 7-Eleven. It's about when you have those curb cuts there, it makes it unsafe. And I know this because my son was hit over by that disaster around Papa John's and Dunkin' Donuts on his bike. And thank God it was very minor and he came through it unscathed. okay? We walk by, that's closed Sunoco all the time, and we walked by when it was going on. It's real safe right now, and I kind of like it like that. And so what I would say is there is this redevelopment plan, and the spirit of that plan and the intent of that plan is make this town safe. So consider not just the needs of the business applicant, but consider the needs of the people in the town. And with that, I will close. Thank you very much.
Thank you very much for your comments. Is there anyone else from the public wishing to speak? I guess we'll start maybe on this side of the room and come across.
Sir, you swear the testimony that you're about to give will be the truth, so help you God.
I do swear.
Your name and address, please, for the record.
Peter Bilton, 219 Montgomery Street. All right, speed comment. Echoing some things that were said before. The street network and building footprints, property lines, those things are kind of like destiny for a town. So you have to think about the long term, echoing what Mr. Nichols said before about the redevelopment plan. Where you put the building is where a building's going to be for a very long time. Mr. Landis's comment about the redevelopment agency considering keeping the building to the south so that it would open up the views of the church and access to the Big Mart lot is great, except that's from a driver's perspective. I'm thinking from a pedestrian's perspective, the best thing to do is have a building pulled up to the corner, have a building pulled up to the street. When I'm walking down the street, I don't care if I can see the church. I care that there's a nice building frontage and wall that's a friendly environment for pedestrians. There's, I think the long term is the thing to think about. There's plenty of other underutilized sites, as Mr. Landis pointed out, across the street on that block heading south that are going to be that way for a long time. If this site goes underutilized for another few years, that's fine. I'd rather have the right thing, the right building footprints there, than have something that's going to be a detriment to the environment of the downtown for 30, 40, 50. My house is 100 years. I've been here 37 years. You know, I've only lived in my house for 8 years, but my house is going to still be there for 150 years, and so are many of the buildings in our downtown. We want to get the footprints right. We want to get the environment of our street right the first time.
Thank you.
Thank you.
Before we go to the next person,
Yeah.
is there any need that we need to rush the people in their talking? I mean,
No.
we could.
But I
mean,
don't-
if people
but I-
want
well,
to come,
here's the-
no, I want to give them an opportunity, but you could come next meeting and we could start with the public.
Well, this is the
Give
point.
people
Well,
time.
So
Not necessary, but I just don't want people to feel like
right.
they didn't
Well,
get an
and I don't want.
opportunity to speak.
Okay, so let me make this very clear that it's been very clear that there are a lot of people that have come over and over, and it seemed like getting out once might be hard. You know, is hard enough, and coming back.
That's
So
what I was
I
gonna
wanted
say,
to
if you wanna
try
ask.
to accommodate. But if people are happy to come back, I would be happier as well to come back. But I didn't want to extend it to, you know, make people come if they've been sitting through a 3.5-hour meeting.
Right,
4
so
hour
whoever
meeting.
can't come next time, maybe they want to speak now, but otherwise.
Okay, so is there anyone who cannot make the next meeting and feels that they would like an opportunity to speak right now before we close this meeting? I see 2 people, and one person, I guess, kind of already spoke, so I guess if you can...
She only has questions.
She only has questions. Oh, okay, I'm sorry.
No, not yet.
Well...
No, not yet. So you swear the testimony that you're about to give will be the truth, so help you God.
I do.
And you have to state your name
My
and
name is
address.
David Hughes. I live at 330 South 3rd Avenue. I moved here with my family 13 years ago for 2 reasons. Because the schools were good and because I could walk and bike from Highland Park to both the train station and to Rutgers. And then some disillusionment set in, and I realized that you couldn't really walk and bike along Raritan Avenue very easily, precisely because of the curb cuts. And then I got hopeful because the redevelopment plan, the charrettes came along. There was a whole process. And there was a wonderful document that everybody embraced, and the people of the town came out and participated in that. And it seemed like government was actually listening to people, and particularly took pedestrian safety seriously. And then the redevelopment agency seemed to get impatient, and this developer, this business came along and distracted them with a bunch of side issues, and they caved, as has just been explained at length. They caved over the one thing that mattered for pedestrian safety. So I'm very disillusioned, and I'm going to continue my practice. My practice is, as other people have explained, you don't walk down Raritan Avenue. You don't bike down Raritan Avenue. I tell my kids, take the shortest distance possible on Raritan Avenue. We go along Magnolia, and we find our entry point to Raritan Avenue. So I never walk a whole block on Raritan Avenue. Never. I go down 4th, 3rd, 2nd. I get to where I'm going quickly. I am able to go to Jack's Hardware, because the Sunoco is closed, and my kids can go there and buy a screw or something, right? If this thing comes along, they're not going to the hardware store anymore, and that's the only one we've got. And let me say another word about curb cuts, because it's actually a little misleading. And I've talked to you guys about this twice, and he's been there, and these guys haven't budged on it. It's not a curb cut. It's a street-level curb canyon. We don't have that anywhere else on Raritan Avenue or Woodbridge. Right? It means somebody's going to come. If these guys are successful, they're going to send a bulldozer or a jackhammer, and they're going to jackhammer away sidewalk and take it and cart it and throw it in a landfill somewhere, and then the cars will be able to careen in on one level. There'll be no speed bump the way a sidewalk usually is. And that's the way they want it. And they've said take it or leave it. And you guys should leave it. You should say no. And if you say yes, it's shameful. It's shameful to everybody from this town who came out and participated in that charrettes and thought that the town was taking them seriously. So do not disgrace yourselves. Say no to this whole thing.
Okay, thank you for your comments. So, well, there was, okay, so I feel like we need to make a decision because it'll keep going on, and that it sounds like people are willing to come next month for their turn at their public comment. So I think we need to.
This is the one meeting I've been able to make it to, and it's very frustrating that 11:20 people non-associated with the project were able to speak. It's very, very frustrating.
Well, that's why, but it was based on that particular comment that we said we're very happy then to open our next meeting. So the first thing that would happen would be public comment. I'm not sure, you know, you kind of don't get it both ways. Either we get to stay and hear the comment, but it is kind of late, or we're very happy. The public comment is important to this board, so do not confuse that issue. The issue is, how do we get it in a timely way? We can either stay a little bit longer tonight and not get through everyone and then start the next meeting anyway. So the concession was, if people couldn't make the next meeting, we're happy to stay those few minutes to hear those comments. So I guess by a show of hands, who falls into that category of not being able to come to the next meeting and hoping to take, okay.
Sure, when is the next meeting?
A month from tonight. The exact date is...
It would be January 17th.
January 17th. Are you in that category, young lady? Either yes or no?
I've had trouble making the meeting.
Okay.
So if there's one person, then I would say, yes, please share your comments.
Am I not allowed to?
Oh,
Not at this
well, do you
point,
have a
not-
comment, or you?
Not at this point. The chair has recognized this lady.
No, I understand Mr. Thomas, but I probably have a similar comment, so I'm just wondering why the order is that, because I'm saying.
Can you make the next meeting?
Because you just simply went up there and the young lady was speaking while you were going up there.
But I'm gonna yield to her.
Thank you. Why don't you do
But I was
that?
up here before, I'm just wondering why you're being arbitrary and choosing. which
I'm not
person
being,
to
no
talk.
one's being arbitrary.
You are being arbitrary.
I feel like I've been choosing, we went from left to right, and then we asked who couldn't be at the next meeting, and I just addressed those people.
You swear the testimony that you're about to give will be the truth, so help you God. Would you state your name and address, please, for the record?
My name is Ann Mishy, and I live at 229 South 3rd.
Could you spell your last name?
Mische.
Thank you.
Okay,
Go ahead.
thank you. I've learned a lot tonight. It's very, very interesting. I would like to express my opposition to the version of the 7-Eleven proposal with the frontal lot and support for something. If not this, it's been critiqued as theoretical, but at least something pressing closer, not settling, or something that is so far away, out of line with the vision of the redevelopment plan. I moved to this town 13 years ago to join the Rutgers Sociology Department, and one of the prime attractions, as many people have been saying, was the walkability. I lived in New Haven, New York City, Sao Paulo for the previous 15 years, and did not drive or own a car when I moved here. This is one of the rare towns. I think we have to appreciate how rare this and precious this is in Highland Park, where you can where I could live and commute to work without driving. I love being able to walk to the supermarket, the drugstore, the parks, almost all the shops that I can need, with a few exceptions. I love the village-like setting with houses close together, helpful neighbors within close reach. Now that I have a child, I have acquired a driver's license and I've learned to drive. But my family still does nearly all of our shopping in town, and we try to use our car as little as possible. Now it's hard to really measure how precious this quality of walkability is. But a simple comparison to the sprawling, car-dependent, more alienating and more isolating suburbs all around us should persuade us that how this quality of life in our borough is something to be protected at all costs. Now, the proposed development of a 7-Eleven on the corner of Raritan and 2nd, with the big curb cuts and the sizable parking lot, would undermine the vision of Highland Park's future that was so thoughtfully developed by the redevelopment plan. This is car-centered development that would create more auto entrance and exit congestion on Raritan while endangering pedestrians. I also have a 7-year-old who is accumulating independence and skipping down Raritan at this point, soaring on his way to his piano lesson, past driveways, and this is worse, I think, than what he would be encountering on this particular block. And I agree with those who would argue that the economy is beginning to regain momentum. Retail investment in residentially appealing, walkable towns such as Highland Park will become more financially available and attractive in future years. And so we should hold out for development that is closer to our collective vision for the town's future, or insist that the applicant respect the rules and the vision of the plan. Interesting about the relationship between rules and vision here. I've learned a lot about something about that tonight. Highland Park has done a lot in the past to make itself a green community and assume statewide leadership on issues of environmental sustainability. And I would encourage us to continue on this trajectory and ensure that future development adheres closely to the redevelopment plan. If we make an exception here, it will be harder and harder to sustain that vision going forward. We want to be a model of a walkable, sustainable community that supports local businesses, encourages neighborliness, participation, and dialogue. The strong debate that's been generated here by this development has itself indicated how much people love our town and care about the future of the community. I urge you not to approve the proposed variance and urge the applicant to present a revised proposal that respects the vision of the town.
Thank you. Okay. Yes, I think I didn't accept you because it seemed like people were making comments, public comment, and you had more of a procedural type of question.
No, I
so,
don't have a procedural type question at all. That's why I was wondering why it was, why it was.
You swear the testimony that you're about to give will be the truth, so help you God.
I do, sir.
State your name and address.
My name is Matthew Hirsch. I live at 333 Felton Avenue. And I would just like to say that I did not have a procedural question, and that's why I questioned the attorney as to why public comment was being arbitrarily chosen. I had a recent experience. It was my son's birthday, and we live on Felton Avenue, just a couple blocks away from this site. And we walk by it a lot. We went out and we got an ice cream cake for his birthday. And then we went grocery shopping to get some food that we were going to cook for dinner. And then we went and got him some books that we were going to give him that night. And I think I have a towel in there. You might be wondering where this is. It was in New Brunswick, and it was terrific. You know, it was the fact that I lived in New Brunswick for 12 years, and that was never an experience that we could have. We couldn't go grocery shopping at a place with fresh groceries. We couldn't walk to a bookstore and buy gifts or buy books for ourselves. And then of course, Thomas Sweets is always there. It's really important for this town to strive for walkability. I am not totally comfortable with alternatives to the proposed application being framed in a what if, but that what if is definitely going to be better than what's being proposed. That said, and one thing I did want to ask Mr. Landis, but something I can just put out there is that I wonder if the Redevelopment Commission considers long-term, and they do, but when they consider long-term economic vitality of the downtown per application, and I'm wondering if the fact that the Redevelopment Commission proposes development that best fosters economic growth in downtowns is part of whether that is considered in whether they approve an application. I'm also wondering if the board considers that as well. This application, as proposed, is a building that sits on its own. Probably won't make parents who are already a little uneasy to be downtown feel any better about being downtown. I'm sure the building will look nice and will serve a purpose, and it will certainly fill in a vacant lot there. That I disagree that it's not better to have a vacant lot there. But I worry if the borough spurns a potential developer based not only on practical considerations, but also ideological considerations, that it jeopardizes our opportunity to attract future developers in downtown, especially when the applicant is a 7-Eleven who can open a store anywhere. And so I just worry that if the borough pushes back too hard against it, it might create a perception in Highland Park that we're not friendly to developers, and I believe that is a perception, whether it's right or wrong. That said, I think the borough needs to I think the board needs to work aggressively with the applicant and make sure that this development represents the aims of the Redevelopment Commission, and that it does, and that it meets all the goals that we strive for, and that it's a safe corner, that it's an attractive corner, that it's a well-lit corner, that it meets the economic development aims of downtown, and that it has housing or office space upstairs, because right as proposed, it's just a shell. It's just a shell space, and that just fundamentally doesn't seem right. So I would urge the board to work very, very aggressively to engage the developer, and likewise, I would hope that the developer, if it does have an interest in coming to Highland Park, which it should, that it works just as aggressively to meet the aims put forth by this volunteer citizen body. And that's it. Thank you.
Thank you. Okay, so at this time, I am going to close the public portion of the meeting and invite everyone to come back. And we will open our January meeting with more public comment. Right now, we are looking at January 17th.
Therefore, the meeting will be carried without further notice until January 17th, 2013. No further notice will be provided.
Thank you, Council and Chair. Just to confirm, we'll start the next meeting with the public portion.
Yes.
I reserve the ability to involve Ms. Ross, and then we'll sum up.
Thank you.
And we need you to sign for next.